May I mentioning item number 45, Lord, I have been engaged day before yesterday, Lord. May I pray the matter may be listed after the vacation, Lord. Earlier, DR Google was there, Lord. So,
Okay.
45, I have taken the concern of the other side also, Lord.
Otherwise, also we are not so interested.
My Lord, because the
Before
last
vacation.
vacations also, that is why I am
Not so interested.
Ah.
But if in a deserving case, definitely.
definitely, my Lord, your
If
notice,
deserving case, definitely will do it. But
Ah.
if it can wait, it will go after vacation.
after vacation, my Lord, there is an interim order, my Lord.
Okay.
That
Interim order to continue. Huh? Mr. P. Bora, Lanet Senior Counsel submits that he has recently been engaged to argue this matter. Accordingly, press for some time. Prayer is allowed. Please this matter after vacation.
but I am for the response number 2.
Interim orders parts earlier shall continue.
But only just feel further order because reason being this, because in the trial court, my Lord, what they ask, my Lord, that whenever the date comes, my Lord,
I know that problem we are facing in many cases. Yes. Even taking recourse to the judgment of the Honorable Apex Court, in some trial courts they have proceeded.
my Lord, so that is why, my
That
Lord,
is, I think, for sent for a reconsideration in
My-
Supreme Court
my Lord.
until further orders.
Much obliged, sir.
May please allow similar for listing of two anticipatory bail tomorrow.
No, that is the already there is a standing order. If the matter relates to this bench, bail, anticipatory or BA, no need to mention, all are allowed.
My lord, here is an issue, my lord.
Hmm.
The issue is this that FIR is not yet filed. There's an apprehensive petition, my lord. Under the
That you file it, we are giving you permission.
my lord.
All are permitted.
May I please, Your Lord?
Yes.
Sir, I beg to mention item number 9, Lord.
Yes.
I may be allowed to withdraw this petition, Lord.
Okay. Learned counsel for the petitioner. What was this matter about?
So there is a bank guarantee loss. Modification of an order passed by the learned court below losses.
Why you want to withdraw?
So that my client has to ask me to return the file losses. So
Okay. Withdraw with liberty?
full liberty loss.
With liberty. Because you are supposed to allow this petition. Withdraw with liberty. Yeah? Yes.
I wish to item 36, Lord. Kindly adjourn for the day, Lord.
Why?
CD is not there.
She did not receive any interim.
No, Lord.
No.
Only period may be given, Lord.
Okay,
From
give a date.
Lakhimpur.
Give a date.
Lordship 10th of
10.
11.
10, 11.
I love
No
you.
interim. Huh?
May please, Your Lord.
Yeah.
I beg to mention item number 11. I am appearing on behalf of RS Mr. Lord.
Yes.
This case, some instructions are required after vacation.
What instruction is required?
After vacation, Lord.
The matter stands adjourned on the prayer of the learned counsel for the petitioner. However, it is made clear that no interim order has been passed against the interim judgment.
Okay.
Pendency shall not be, but you want to stay. Is not
Lordship,
it?
no, I'm appearing. RS Mr. is not available also, Lord. So I'm appearing,
Understand, but what is the matter? It's a maintenance.
Lordship.
Maintenance was reduced.
Reduced, Lord.
Okay, okay, simply adjourn.
May I please?
Obliged, Lord.
Yes.
I beg to mention item number 39.
30?
39.
Yes.
Earlier CD was called for.
Yes, madam. Any interim?
Yes, I am on interim.
Interim to continue when?
Lordship on 23rd.
23rd. Yes.
My please, Your Lord. Lordship, I beg to mention item number 48, Lord. Lordship, today is some difficulty, Lordship. Okay. 48, Lord.
Okay. Adjourn.
Obliged.
Please, Lord. I beg to mention item number 44, Lord. Item may be taken.
44 already mentioned.
44 is not.
44 is not mentioned.
Pranbora.
45 mentioned.
45 is
It was 45.
after vacation.
44. Okay. After.
Obliged. May I please, Lordship? Lordship, I beg to mention item number 49, Lordship. With the consent of the other, maybe adjourn.
49. Yes. After vacation.
Okay.
After vacation.
May I please, Lordship? Lordship, I beg to mention for listing on tomorrow, Lordship, criminal appeal, Lordship, motion matter, Lordship.
That cannot be, you cannot make mention here. Go to the senior bench. Senior bench. Russ, yes, next.
I beg to mention for listing of the criminal appeal. Because last case is
Civil.
May I please, Lordship? My lord, in respect to item number 27 to 32, Lordship. My lord, yesterday, Lordship, this honorable court has retained the case that of Darabhai PS case number 523. That, Lordship, club matter, Lordship.
Okay.
Lordship has retained the case diary yesterday. So these matters are connected with the case diary,
Okay,
Lordship.
27 to
32, Lordship.
32. Yes,
Lord, the case diary may be provided for.
case diary. We saw the case diary yesterday, na? Then you give it to him.
I am obliged.
He almost me. Huh? No, I don't. It took you all. Mr. Botagor, your case today also no name reflected.
We have informed them.
You have informed them, na? And there is a office note also. Saying that name is reflected.
Sure.
We have called the concerned person.
May it please. FIR 439 application Lordship. FIR is at page 28 days.
What is your age? Tell me. 52. And what is the age of the victim? 18.
On 10/11.
10-11. You should file search sheet here.
Yes.
You file search sheet when boy is 19 and girl is 17.
That is it.
And you put a young man behind bar during period. You should file a search sheet in this kind of case.
Lordship.
May I please, Lordship? Lordship, in this case.
See, this is the case. He is 22, she is 15. And already so fast search sheet file. Scan copies. What to do? No way out. When?
Lordship, any date as per the convenience.
Yes, give a date. Fifteenth of March. No way out. What to do? Again on that day it will not come. We cannot pass on order.
It is a court.
We know that. Problem is that it is not coming. There is a vacation in between. When? Okay, give an early date.
10th, sir.
10.
10/11.
Okay.
Hello. File today. That will be corrected in order to the extent of registry after such correction is in the meantime a matter to list follow the registry to list dispute on 17 and reflecting the name of planet PSGI Union of India as well as senior government with examine the first list of name. It is as per high order suspension Union India as well as the landed advocate Assam are as reflected where it will reflect it to click where reflected could reflect
One, two.
reflected
One and
could
two.
reflect
Three to local.
in cause list to cause list to নাম কোন আছে তে মাথা বলি কোনে কৈছিল দুইজন ফলো কৰিছে
Maybe the law. 39 bail application your lordship. Allegation under section 376 of IPC or
which item
376.
376 of IPC.
CD
Lordship, 10/11.
Many people. Lordship, here, 439 application and petition
CD.
and Lordship, may I place one thing? Here, in terms of the fact, detail in the fact, 392 is not attractive. Because.
They are
Lordship-
bound to add 392 because of the conduct of you.
No, Lordship, I was standing at the place of the occurrence. I was waiting
We'll
for
see
my
that,
friend.
we'll see in the case then.
If they have said
The
tomorrow,
citizens are,
I'm not named in
Hara-
the appel, Lordship.
the citizens of Guwahati are not even able to move freely. Therefore, they have started adding 392.
Lordship admitted, Lordship.
CD.
Lordship, मैं speak से shortage,
I do
otherwise
not know.
Lordship,
Tell.
मैं shortage. Otherwise he's suffering
We
from.
can
a
try
very
on
headache
day after
disease.
tomorrow.
Yeah.
At best, we can try on day after tomorrow,
Yes, Lordship.
if it is so.
Lordship, kindly
I
Lordship,
don't know whether it will come.
kindly Lordship. He's suffering from AIDS also, Lordship.
Suffering
not-
from?
AIDS, Lordship, I'm told.
He'll definitely, because he's having the drugs,
No,
injection,
not,
then therefore he need money, therefore snatching.
no, Lordship.
Better he let him be there with the state hospitality on 3110.
Apply.
Lordship was pleased to reject this earlier, Your Lordship.
CD.
We have a prayer for interim protection, Your Lordship. This is because, Your Lordship, certain materials are not placed, Your Lordship.
I have seen that.
The opposite CD may be caught for.
He went with me, Your Lordship, after marriage, Your Lordship. Solemnization of marriage, Your Lordship, under special marriage act. By flight, different places, Your Lordship. And one thing I will admit, Your Lordship, there is a quarrel between them before marriage, Your Lordship. And I suggested that let us have an agreement that if we have quarrel go on, then we'll go for mutual divorce. That suggestion I have given, Your Lordship, and that creates the entire problem, Your Lordship. That I will admit, Your Lordship. But otherwise, Your Lordship, everything, Your Lordship, by consent of it. And 376 will, Your Lordship, remotely not be attracted, Your Lordship. Even if it is a rape, Your Lordship, it is a marital rape, Your Lordship. And the Honorable Supreme Court is still decision of the matter, Your Lordship. But
These money are paid for what purpose?
Your Lordship, instead of, Your Lordship, giving these gifts, Your Lordship, their family wanted that I should construct everything, Your Lordship. I should procure everything, Your Lordship, in the house itself. That's what.
Now, how do you say that from this statement that
Your Lordship, you will kindly see, Your Lordship. This is, Your Lordship, they willingly, Your Lordship, deposited the amount, Your Lordship. Had there been any demand, there been any objection, Your Lordship, that would have immediately, they would have filed a case, Your Lordship. That is not the case. Everything they have deposited, Your Lordship. I have annexed everything, Your Lordship. Preparation of marriage, Your Lordship. Purchase of goods, Your Lordship. Everything. Now, basic grievances, Your Lordship.
okay, CD interim?
Deeply obliged.
On 24/11.
Wait, please.
Yes.
This is the matter relating to a serial number of FIR. Then the first FIR is page number 12. Actually, my lord, the complainant and the petitioner, the accused are the brothers and sisters. And yes, and what happened? The doctor, the FIR says that he has poisoned her with a cup of maza. They are running after courts and coming and going in police station and going because they are with that 2015 case, GR case. With that, they are dragging.
Our sheet has been filed or what?
Yes,
ma'am.
Lordship.
You will have to call for the scan copy.
Yes. So he was a
You-
founder in the.
you are-
That he is said to be a founder, but they're happily married and staying, and their husband and wife, they're
Oh.
having children. Yes, my lord. Only with that prayer I come before your lordship, for a prayer is failed. and he's afraid of going to the court and.
I'm
So
not
he has
getting
done-
anything. Please tell me.
My lord,
Page 20,
this-
Lordship.
Huh?
Page 20,
Page
Lordship.
12 is the. Page
Page
12 is the
20.
FIR.
Later on, Lordship, NBWA issued against him, Lordship. And 27/7/2022 for appearance. Thereafter, what happened, Lordship? Nothing.
Basically, my lord, the matter relates to an old FGR case, 2015.
Mhm.
What happened? He appeared and he prayed for bail. The bail was rejected. But now the main crux of the matter is they are married and they're having children. They're happily staying.
Where is
But-
the statement?
They're
Statement.
stated.
Huh?
Yes, my lord. They're having children. He's a wage earner, daily wage earner, my lord.
Where is your statement that you are living
There.
together?
Yes. That the petitioner begs to say is a daily wage earner having
Page-
minor children. Page
Where
number
paragraph?
4, paragraph 5, my lord. And having minor children, aged parent and all the members and family are dependent upon him. That is humbly stated, the informant, namely Makkatus Ali, is the uncle, and the victim is the
No,
maternal
that you
sister.
both are living together.
Yes.
Where is that statement?
That the petitioner begs to say that he is a daily wage earner and having
Page-
minor children. Page number 4, my lord, paragraph 5.
That is not a statement that you are with the victim staying together. That after this
No,
case,
yes, my lord, that I am the husband of the victim comes in paragraph 7 also. The facts of the case in brief is that the instant FIR was
no,
lodged.
no, that
with
you are
the
the husband, there is no dispute. The
Whether it was
problem is that you are saying
Yes,
that after the case was lost, we are now living happily.
yes, having
Happily,
children.
where is that statement?
Happily.
Not happily,
I will
that
not
you are
say,
ma-
but
you are-
they
you are
feel
together.
Scared, yes. So we, not
It's
happily,
that
but.
I am a
it's
wage
sure.
earner, daily wage earner, I am
Lordship,
having
most
minor.
probably paragraph 8, page
Yes.
5.
I have stated the fact that the facts of the instant. That the petitioner begs to say.
That is what I am
Yes,
asking.
yes. That the petitioner begs to say that after a short period, the
Ah.
said FIR was lodged, the dispute between the informant and the petitioner was amicably settled, and at present the victim is married and leading a happy.
Now, how
conjugal
we
life.
ascertain this? If your wife a party, you would have filed a joint application.
Here, continue.
How do we ascertain it that she is correct? She is not a party, or she ought to have been either a petitioner or she something
Yes,
so that
Assuring that. that
now
the-
if we call for the scan copies, we'll get her statement which was recorded under 161 earlier.
earlier,
That implicates you.
Hmm.
Even if we want to give you a relief,
yes, that-
we
that-
cannot right now. On what
is-
basis we'll pass an order?
But that is the fact. Any favorable direction so that
Hard
he will be safe
Miss-
from this non-believable
Learned Counsel
warrant.
the petition. Pushpa. The present application under section 448 is filed for grant of pre-arrest bail. Filed 2020. In connection with 2020. The petitioner is an surseated accused in connection with the opposite case. And in the surseat dated 31/12/2015, petitioner has been declared an absconder. The petitioner earlier approached this court, I approached the learned session judge for bail. However, he was such bail prayer was refused. The allegation in the FIR is that the petitioner mixed poison with a bottle of cold drinks and gave to the accused. And after taking the same, the accused fell ill. The victim fell ill and she was to hospitalized. Full stop. Such FIR was lodged by the victim, the father of the victim. Statement has been made in the present petition at paragraph 8 that it was filed by informant. Who filed the affair?
Father of the.
Father of the victim.
Now you said
Father of the
have-
wife.
Huh?
Okay. Father-in-law of the,
Father-in-law, but in your statement you have said that
but
you have
no, their brother.
you are married with your father-in-law. According to paragraph 8, you are married with your father-in-law.
I think the girl is also there, I guess.
The informant. Be careful. It's a question of
Yes, fine.
liberty of a person. A statement has been made that the victim and the accused subsequently got married. They are having a happy conjugal life with two minor children. Considering the above statement as an interim, it is provided that the petitioner shall not be arrested in connection with
Yeah.
In the meantime, the petitioner is permitted to file, petitioner is permitted to file an affidavit through affidavit of his wife
No.
confirming such statement as made at paragraph 8 of the.
Yes.
If you are right.
23rd 11.
Both these are two is there, but your lordship,
Except
Yeah.
Nazir,
yes, ma'am.
except Nazir interim, city interim.
Obliged.
Accused number 1. Nazir is accused number 1.
Yes,
Yes.
yes.
Interim. Except Nazir,
Lordship on 22nd of November.
give your statement.
That is the Lord. 438 petition, my lord. FIR is of 2011. Charge sheet was submitted on 2019.
Why have you filed AB? Tell us, why don't you file an application under 482 by both the person for quashing?
Yeah.
We could have allowed right now.
Yeah.
Then what is the meaning of giving you anticipatory bail? It's a case of quashing the entire proceeding. 498A,
Yes,
isn't it?
yes.
And they are happily married.
Happily married, having children, my lord.
Happily married children, no
2014
problem. Why don't you file an 482 application?
Lakshmi Narayan case. is there.
So you want to contest the 490-day proceeding getting anticipatory bail. File an application. Make a mention on Friday. Withdraw this file and possible.
Before vacation, my lord. Because the problem, the parties are from Nagaon, my lord. He is doing a very menial job, my lord.
It's an sorry to say, it's a absolute non-application mind of the lawyer. Sorry to say. Hard. The learned counsel for the petition. Also hard. The present application under section 438 of the Code of Criminal Procedure is filed seeking anticipatory bail in connection with Nagaon PRC number 1120/2020 registered under section 366/34 IPC 36 for IPC. Full stop. The case of the petitioner is that the alleged kidnapped victim and the petitioner got married, and the victim on her own will elope with him, and they are now happily married. Where is your statement?
The affidavit, my lord, is at page
Ah.
29, 31.
In this connection, the learned counsel also brought to the notice of this court to the affidavit filed by the alleged victim Full stop. Considering the above, it is provided that the petitioner shall appear before the learned
Go to
Court.
CGM.
CJM Nogam.
learned CGM Nagaon. CGM, it's
CGM.
reliable by CGM.
Yes, CJM Nogam.
Learned CGM Nagaon, seeking irregular bail, considering the matter in entirety, including the affidavit sworn in by the victim. It is provided that till determination of such application, the petitioner shall not be arrested or and put behind bars. Take your wife to the court.
The PRC number is now 2022 man. 1120
1120/2020,
22
What have I said?
2020.
2020. 1120/2020.
Obliged. May I please all? No case for both are belong to same community. One sentence only because of it. Because actually the informant part, they were any specialists were loitering around in the near the house.
City interim.
on 28th of 28th. Great.
That's it. As
Uh,
many as 4 FIR, my lord.
all for the case diary of
My lord, Align PS case number 214 of 2020.
and
And my lord, this is a vital matter.
Huh?
This is the
no, the one given by Rahima.
Rohima,
Rahima is wife of Anwar,
Anwar, my
and other is by
by father of the victim. Annexer 1, father of the victim. That is my lord,
and other is Qabil Hussain.
Kabil Hussain, son of the victim, brother of the victim. Brother of the victim.
And other
Other, my lord, Annexer 1, my lord,
there is a counter also.
counter also, my
That is what we want. We want to both the cities.
my lord. Then my lord, Kalan PS number 213.
There are two cases, one from your side
Yes.
and other from the other
Victim
side,
Victim side.
victim side. So give us the death too.
My lord, Kalan PS number 213
Hmm.
oblique 2023.
This is by
This is by Rohima. Petitioner number 1.
petitioner number one.
And my lord, another my lord, Kalan PS number 214 oblique 2023.
This is
That-
by
Brother of the victim. I am taking bail in this case, in this FIR.
214.
214.
There are two cases, Lordship. One is 214 and one is 213.
same incident.
Same incident.
I thought there are
No.
two cases, one against each other. Is that it?
Yes.
Each other, my lord.
Huh?
My lord, what happened, my lord? May I clarify, my lord? My lord, victim eloped with the Anwar. And father of the victim lost case under section 373.
Hmm.
Victim came back, her statement recorded, and Anwar was put into jail.
Hmm.
Thereafter, victim, my lord, consumed poison.
Hmm.
After consuming, my lord, the victim side burned down the dwelling house of the Rohima. Everything. Rohima filed PS case, another FIR. And thereafter, victim died. Victim died. My lord, then my lord, brother of the victim lost another FIR, 240.
And one more FIR, Lordship, that is at page 11.
No, which are necessary? Case diary to be called in which case?
Lordship, the present cases will be required.
Sufficient.
Sufficient.
Okay. City will give him interim.
My lord,
Yes.
City interim.
Obliged.
Which case?
My lord,
214, Lord.
240.
240, na? File. So many cases.
Obliged. So many cases.
Yes, CD2.
City
Lordship on 15th.
50.
Obliged.
Go and give your statement.
Yeah.
Lordship, I interim is granted then on 23rd.
20.
Obliged.
Yes, in this case, Lordship, case diary may be called for, Lordship. All the,
Second time.
yes, Lordship, all the accused arrested in connection with this case has been released by the,
So you also go there, come back. Huh? Once you have rejected, today I would have given you the bill. Did after
On
2 weeks. Huh?
28,
Huh?
28/11.
20. None appears for the petitioner on call. Scan copies. Call for has not yet been received even after issuance of reminder. Registry to seek an explanation and call for the can list it on
16/11.
1611. Maybe a little bit later.
Not
It's not 1611.
16/11 motion. Very.
Yeah, please.
Yes.
It's a revision petition against the order passed by the learned session judge Morino in connection to NI 138, where the petitioner appellant was sentenced to pay commission of 7,68,500, which was included with the stake amount and the
Okay.
interest.
Interest forget about.
Yes.
How you deposit the rest?
Okay.
You deposit the rest.
And Lordship, now thing is that the apex court is very clear that there must be a legal enforceable debt. But this is missing in this case, Your Lordship.
There is also equally well settled that in case of concurrent findings by two courts, in case of negotiable instrument act, this court can see only on the perversity, not as an appellate.
But the complaint itself also is also missing there. That
And there is also the judgment from the apex court for deposit, insisting on deposit, and there is a statutory mandate of deposit. Tell us about that.
now, Lordship,
We'll come to legal debt later on. Tell us about that provision.
Lordship, the first thing that when the complaint was lodged by the complainant,
No, tell us about deposit. Then we'll proceed further.
the deposition for only 2 months was granted for the entire amount to be deposited. Your Lordship. And
Now tell us, you give a proposal, or we are dismissing right now. That this is not a case for revision.
as your Lordship thinks that, he will deposit some amount of money.
Tell us, you have instruction. Don't give a statement on your behalf. Please this matter on 19th. In the meantime, petitioner shall obtain instruction regarding the amount that the petitioner shall deposit
Can it
in
be
terms of section,
Can it be listed tomorrow?
under section, what is the provision? NIA
That one.
143A of the NIA. Day after
Maybe listed tomorrow or the day after tomorrow. There is
tomorrow. Have the instruction.
Yes.
Go through that provision and come back. And appears for the petitioner on call, list of the petition.
Well, I think that judgment has been, 1 second, that order, judgment of the learned single judge in that case, there's Nilim Mehdi, as bail has been cancelled. Suppression of material fact, it has been cancelled. That's very important, and I know he will know, my lord learned friend will know what is there in the case diary. Suppression of material fact.
Yes, what you say?
What more, my
all
lord?
legs input number 15 minutes. After some time,
If suppression of material facts are there, then it's difficult.
But in the,
That's
you know,
what we-
Nilam Mehdi, who has moved this bail AB before this honorable court, he projected this as Nilam Mehdi, but allies Nilam Kashyap got an interim bail. Thereafter, my learned friend showed, and I appeared before I mean my learned friend appeared for a trial court, and Deepshika has got bail on the basis of Nilam Mehdi's order. She said in the trial court.
Now Nilam, Deepshika's case is when?
It's 19. Let the case diary be, the learned session court will look into the case diary. That's my exactly opposite of the judgment. My great respect, I am saying Niharika judgment. But they have relegated to under 438 before the learned sessions court. I leave to your lordship, my lord. This is
Since he says he's senior, let him say, let his senior come.
Is there
You be with the case diary. But after we finish the list, you ask your senior to do other cases.
okay.
Lordship, healthcare may be called for can copy.
Can copy the healthcare. In connection with
Date may be
give a date.
obliged.
May I please call? The 482 application, Your Lordship.
You are a bank manager.
Yes, Your Lordship. Your Lordship, what happened here? Respondent number 2.
Oh,
He-
tell us about this one thing. What is this page 47?
Page 47 is the computer generated. This,
Who did it? On
is the
which?
bank, Your Lordship, bank. From the bank,
Then mistake was on whose part?
from the bank, we have taken this one, Your Lordship.
No.
Yes.
According to the petitioner,
Yes.
money was supposed to be transferred
To some other account.
to accounts of A.
Yes, Your Lordship.
You have transferred it to the account of B.
Yes, sir.
It is whose fault?
This is the fault of the respondent number 2, Your Lordship.
Who
He
is
has
respon-
provided wrong account number.
Now this annex this
Your
47.
Lordship may kindly go to page number 27, Your Lordship. That is the application for fund transfer under RTGS and EFT.
That is what I want to see. I
Yes.
thought that is the application.
No, Your Lordship.
Page 28.
27, Your Lordship.
This is signed by
Signed by Raju Das, Your Lordship. He is the respondent number 2. Here he has provided account number 26230,210.
no. Raju is the beneficiary.
No, he's not a beneficiary. He is the transfer.
Wrongly transferred to him.
No, Your Lordship. He has transferred to someone else.
Who is the informant in the affair?
Raju Das, Your Lordship.
Where is the affair?
FIR is page, Your Lordship, 18, 11 page, start from 21, Your Lordship.
Okay. Hard. You are Mr.
S. Dekar.
S. Dekar, learned counsel for the petitioner. Also hard learned edition of the petition. Is an application at the taking to the it is alleged in the affair that though the informant has asked the bank to transfer an amount of rupees 2,40,000 to the account of one
India Bulbul.
Imtiaz Bulbul Ahmed. However, the bank has transferred it to one
Sunil Kumar,
and the Sunil Kumar has already withdrawn the amount. Referring to the Annexer 3, which is an application for fund transfer filed by the applicant, the learned counsel for the petitioner, who was the bank manager at that relevant point of time, submits that the informant himself has given the bank account number of the
Imtiaz Ahmed. Wrong account number has been provided.
A wrong account number has been provided, though the name of Imtiaz Bulbul Ahmed was written. He further submits that it is the bank account number on the basis of which money are being transferred. This method needs further consideration. Accordingly, it is provided that until further order, the further proceeding of further investigation in case of all for the case diary
Yes, sir.
of Karimganj PS case number 672/2023 under section 406, 409 and 420 IPC till receipt of such case diary, considering the matter in entirety, the further investigation of the aforesaid case is the
Highly
After 4 weeks,
notice to inform and you have made a party.
yes, sir.
Notice to inform and by register as detailed.
May is a lordship or complaint case means CR case number 3707/2018 was filed under section 130 of the Negotiable Instrument Act, and the petitioner was arraigned as the opposite party number 2. Said lordship thereafter, lordship almost after 6 months, and lordship the complaint petition was filed on the mistaken belief that the petitioner was the sole proprietor of the opposite party firm number 1. Thereafter, lordship, after almost 6 months of filing of the complaint case, lordship, an amendment petition was filed, wherein lordship in paragraph 2 of the petition, lordship the complaint themselves admitted that now it has come to their notice that while filing the complaint petition, the opposite party number 1, the sole proprietor, is not the opposite party number 2, but one Mr. Tomo Basar, lordship. And thereafter, lordship in
Notice was issued to whom?
notice was issued to the opposite party number 2.
Now they say that opposite party
Party
number is
2
not
the sole
not a
proprietor, but it was under mistaken belief, lordship. And also, lordship,
How-
paragraph 4,
oral and concept P or
lordship P. Barwal,
P.
lordship.
P or R. That is the
P.
confusion.
P.
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 P. Borough Learned Concept. The present application is filed against the order dated
Lordship, order, lordship, we are not impugning because in the order also, lordship, the court has allowed the amendment petition. And now, lordship, no case lies against it because in the application, lordship, the complainant has stated that the opposite party number 2 is neither the sole proprietor nor the drawer of the check. And the order has been lodged, the order has allowed the application, amendment petition. Therefore, lordship, now no case lies against me. Complainant themselves admitted that I am not the drawer of the check. Therefore, lordship, we have approached this court to set aside the complaint against the petitioner.
okay. The respondent number?
Lordship, opposite party number 2. Petitioner is the opposite party number 2.
No. Who filed the case?
Lordship, we respond.
Respondent number?
Lordship, one respondent.
The sole respondent filed an application complaint case under section 138 of the Negotiable Instrument Act, wherein the present petitioner was arraigned as accused number 2 in the said petition. Subsequently, an amendment petition was filed to the effect that by mistake, the respondent number 2 has been arraigned as the
Lordship, the petitioner.
Petitioner has been arraigned as accused number 2, and accordingly an amendment application was filed for arraigning whom as the
Mr. Tomo Basar, who is the
uh,
sole proprietor.
arraigning the sole proprietor of one
Proprietorship.
Amrit Cement Limited, isn't it?
No, Lordship, Lordship,
sole proprietor of
Lordship, our firm is not Mrs. Eastern Trading Agency.
sole proprietor of Mrs. Eastern Trading Agency, and it was a stand that respondent number present petitioner has wrongly been arranged as respondent number 2. Such petition was allowed by the petition was allowed by the learned court below, and in view of such development, the learned counsel for the petitioner submits that the present petitioner cannot be proceeded. The proceeding cannot be allowed to be continued against the present petitioner. Full stop. This matter needs further consideration, issue notice, considering the matter in entirety, it is provided that the further proceeding of the so case shall remain suspended so far relating to the present petition. However, the same may proceed in terms of the
Party number one.
against the other accused in terms of the decision of the court, learned trial court.
Deeply.
হচ্ছে clear করছেন। আমি চেষ্টা করব।
The person is suffering after 2 orders. The other side will come and say that our name is not, so we are not able. The person is behind bar. It's his right under Article 21 is concerned. You cannot be so casual. You cannot be so casual. There is an order here. There is a office note that as per why contempt shall not be drawn that this is a wrong statement has been made. Be careful, be
Yes,
careful.
sir.
The young Yes, sir. What is this?
Malad, because of the supplementary charge sheet, Malad, my name has been included, but they have stated that FSL report is yet to come. And Malad, some other documents which I have placed were never considered. So Malad, this is a case of a further investigation. And I pray for a further investigation, Malad. Till then, Malad, some relief, Malad. Your Lordship may look into that. In the FI, my name was not there. Page 32, Your Lordship will find that in the third paragraph, it is mentioned. It is to be mentioned that the FSL report and report of UGC Head Office requiring information and document regarding scholarship. Page 32 is a supplementary charge sheet. Third paragraph. Third paragraph, it is to be mentioned FSL report and report of UGC Head Office Delhi requiring information and document regarding scholarship has been, and the report from Director Chororia Development and State Nodal Officer Guwahati yet to be collected and yet to be yet to be collected. These were not collected. And my lord, some documents I have placed, my lord, where my lord I have asked at page 37 before the FIR was lost for cancellation of any scheme in my college. At page 37. And my lord, the UGC letter has come at page 39, where they have said that in this college, nothing was given in the name of that scheme. Page 39, UGC Under Secretary has said that it is informed no student was selected from Uttar Barpeta College, Assam under Ishan Uday Special Scholarship, and no scholarship amount has been processed to the student of this college under the
They're
scheme.
too fast. Just give me some time.
Page 39. My lord, before the FIR was lost at page 37, I have made a prayer for cancellation of any list in my college name. That is on 15/11/122, and the FIR was lost on page 20, 30, 10, 20.
When the affair was lost,
Page 20, 30, 10, 22.
30,
10, 22.
10, 22. Now, how have you sent this letter to?
Because there was already some information going on that in that area, some mischief has been done. That is why, my lord, I made a letter that if anything in my college is there, please cancel those. And ultimately the
When FIR was lost?
30/10/2022.
30/10/2022.
30/10/2022.
page 20, my lord.
Now you email on 2/1, that is after the FIR,
My lord.
but you did not email it when on 15/1. How do you know that you have sent this
My lord,
15/1 letter to the
15
UGC?
My lord.
Why we not think that this is an afterthought?
My lord, I understand your lordship query, but at page 39, the reply is, they have said in my college there was no scholar, no amount was. Page 39, the reply.
So then why you are worrying?
My lord, because my name is in the charge sheet, they have supplemented the charge sheet in my name. I was arrested, I was put behind the bar, I am suspended, disciplinary proceeding drawn. And I am a principal of a college. It was the letter from,
This will have with you the original copy.
my lord, that is why I placed the original copy, my lord.
Yeah.
My lord.
You during cross examination you confront
Well,
with
that
this.
is what I placed, that this is the case of a further investigation. Because, my lord, subject to all my restrictions, my lord. My lord, I just relied on one judgment of 2009, my lord, where in three conditions, on new facts, on end of justice, and on unfair trial.
They're issuing a notice for a time.
My lord, till then, my lord,
Scan
only in
copy.
respect of me, not for others.
Scan
Only in
copy and
respect of me.
What suppose we do not say what prejudice will be caused you at this stage?
My lord, because again I will be called upon in the court, my lord. Summons will be issued. Again I have to appear.
Search sheet has not yet been filed.
But filed, my lord. Second supplementary search sheet has been filed. The first one has been filed, second one has been filed. That is why I say, my lord, when the official reports are not yet come, again they will, it's the case of a further investigation.
FSL in respect of what?
My lord, at page 32, FSL report from UGC head office and others.
Because now whether when you were arrested,
My lord, I was arrested on my bail application is that page. Bail of judgment is there at page 22, my lord. This is
No,
my order of bail.
tell us the date.
My lord, I was arrested on, when was I arrested? It was, here in the judgment is not there, my lord. From the date, my counsel has stated that there was no way involved, but I was arrested immediately.
When date very vital, that date is very vital.
30/12, my lord.
30
12/22.
12
22.
2022 arrested. 30/12/2022 you were arrested.
And I was put under suspension on 4/1/23.
Still you are under suspension.
No, Lord, I have been revoked. That is,
Yes, madam, what do you say about
So
this?
at this stage, notice should go to the respondent and scan copy of search sheet of it. Along with the LCR may be called.
Where is someone?
A someone, right?
We call someone and have see a authentication of this document. Whether UGC has actually, because we are having a doubt in our mind. We were arrested on 30/10/2022. And prior to that, you smell something.
my lord, here it is
On
stated,
15/1/2022, you write that please cancel all my things. Why?
because there was already, my lord, some kind of.
Now
this going in
UGC
corporate.
says according to you on 24th of February 2023. Now why this clarification has come? We want to know that.
Because of this, my lord, page 38, therefore clarification regarding page 38, I have made on 2/1/23. Therefore clarification regarding issue with the scholarship scheme received or not received by the student of WhatsApp. I made a request. That is why the reply as well.
But there is no reference of to your letter. Generally, UGC do not write letter like this. There must be a reference to your letter that in reference to your query dated so and so, this is the reply.
But only thing is that there is a memo number. If
Memo number may be also manufactured. Who knows it? See, it's UGC. It's UGC.
It's not.
It's not any think
can
Harry institution. They will give a clarification without any reference, without anything. This is clarified that so and so college is not having any difficulty. Whereas you write according to specifically write give a number. Without reference, you will get give. So that's why you're calling for the scan copy.
True. Only your lordship is calling for the scan copy. Whether it is a case of a further investigation or not.
We'll examine that.
Till then, if it is a case of further investigation and FSL report has nothing has come forward.
No. Even if it is not a further examination, you can confront with them with this. This is you are having the original. You are having the original with you. Confront. See, this is the UGC. You are acquitted on this document only. Why you need further investigation?
Because this thing, if it comes.
You want a stay of the proceeding against
no, but not against. Against everyone.
against you.
Only
But
thing is
you are having the main documents with you.
if it was taken by them during investigation, they would have submitted a final report against me. There will not have been an abuse of the process of the court against me. Or should I appear? Because if this were taken and they would have submitted a final report that nothing is there against you, they could have verified. That was the fair investigation and for which they should have filed a report. That is why my case is for further investigation under 173A. That is why I relied subject to correction on judgment. There are 12 and 16.
Have you filed any application before the magistrate?
No, because both the court, either superior court or the trial court, both the court can. Here it is stated as the superior court.
Why have you not filed the application?
Because
before the
reinvestigation
court?
power
Who is having all these
because
documents?
the investigation and investigation for the investigation power is only with the superior court. It cannot be by the trial. Only by the court.
Is it?
The investigation power is only for the superior court, not by the trial court.
Where is the provision?
173 is there. 173A. It says about evidence.
What about 173 subsection 8?
That is what I am saying.
What that provision says?
Yes, my lord,
Read it.
173A.
Read it.
173A.
Subsection 8.
Nothing in this section shall be deemed to preclude further investigation in respect of an offence from a report under subsection 2 has been forwarded to the magistrate. Whereupon such investigation, the officer in charge of the police station obtains further investigation overall document shall be forwarded to the magistrate. Further report or report calling such
So power, whose power to further investigate?
my lord. My lord,
Whose power to further
my lord, here
investigate? Subsection
he
8
shall
of-
forward to the magistrate a further report.
This is a power of magistrate. You are saying
My lord,
magistrate is not having.
magistrate, my lord, he shall forward to the magistrate a further report. The investigation officer will submit a report.
Understand.
My lord,
This is it. You said that
this is
magistrate
the
is
power
not
of the
having.
investigation officer. This is the power of the investigation officer. He can go for further investigation. Because here also,
No, who can, you have said that magistrate is not having
Reinvestigation-
power to grant.
the investigation power under 173A is not by the trial court. For
One,
investigation, it is further investigation.
so
Because
then
there
he
is
will
a
give a,
distinction.
what
There
is,
is a distinction between a further investigation and reinvestigation.
understand, why should there be reinvestigation? Because a new documents and
My lord,
come,
Then it's.
he will do a further investigation and file an application before him.
my lord, at
We are
least-
giving you liberty.
my lord,
He will having all the documents before him.
my lord,
You
your lordship may give me that liberty, that man, that I have been allowed to go and file a application under 173.
You are always at liberty.
My lord, with that observation, may your lordship make. My lord, and the scan copy, my lord, with the interim liberty may be given and the scan copy may be.
Not
The
at this stage,
first
not
word.
At least something else.
FT something before puja. List is after vacation. That is the order you can get, not more than that. Hard. Mr. Rajpaturi Learned Counsel for the petitioner. The present criminal petition is filed by the petitioner for quashing. You have filed it for quashing.
Question.
Ground is for further investigation.
Charge sheet dated 322/2022. Charge sheet being 322/2022 dated 6/5/2023. Submitted by the investigating officer in connection with Borpeta PS case number 105H/2022 under section 120B/468/471/420/417 IPC corresponding to GR case number 1994/2022. The basic ground for seeking such quashment is that the petitioner is no way involved in the aforesaid case. The case was registered. The aforesaid Borpeta PS case was registered on the basis of an FIR. Where is the FIR?
Page 20, ma'am.
On the basis of an FIR lodged by one SI Biswajit Nath alleging scam in granting merit scholarship under Ishan Uday, MCM pre-matric scholarship scheme through National Scholarship Portal, and it was alleged that many scholarship has been released in the name of fake students. The relying on a clarification. In the aforesaid case, the petitioner was arrested and subsequently was released on bail. He is a principal of Uttar Borpeta College and Uttar Borpeta College. Referring to Annexure 9, the Learned Counsel submits that the petitioner has sought for an clarification from the UGC, University Grants Commission, that whether any scholarship has been released. So far, the same relates to Uttar Borpeta College. According to Mr. Rachaudhuri, who, referring to Annexure 10, submits that the UGC has granted a clarification that Uttar Borpeta College, no scholarship has been released in respect of Uttar Borpeta College. On the basis of such document, the Learned Counsel has sought for an quashing of the search. But your prayer is quashing of the search. While during course of argument, Mr. Rachaudhuri, relying on a decision of the Honorable Apex Court in the case of Kishan Lal versus Dharmendra Bafna and another, submits that in view of the aforesaid document, a further investigation is required, and this court should direct for a further investigation in the case. Full stop. Full stop. However, it is an admitted position that the petitioner has not approached the learned trial court for such further investigation and straightaway made a such and submission. Full stop. In that view of the matter, this court is of the view that only on the basis of a document submitted as annexure along with the present petition stated to be a clarification from the UGC, this court cannot quash a criminal proceeding wherein after investigation charge sheet has been filed. However, the magistrate shall be at liberty for further investigation in terms of section 178, subsection 8 of section 178, if
73.
173, if certain new materials are brought to the notice of the court. In view of the above, the present application, in view of the above, Mr. Rashidi submits that he may be allowed to withdraw this present application.
Not withdraw.
In view of this, that in view of the aforesaid reason, this court is not inclined to entertain the present application. Accordingly, the same stands dismissed. However, the petitioner shall be at liberty to approach the
Or in the alternative, may like to call for the scan copy if it is dismissed or not. That will be having an effect. Lordship may call for the scan copy.
what is the meaning of scan copies? Can we quash on the basis of your document?
Your Lordship,
Just tell us. Can this court quash only on that document without there being any authentication, any verification?
Yes.
That is a matter of investigation,
that is the matter.
is not it?
Well,
Now, what will you do?
Further investigation.
But your
will be
Lordship may
required.
not observe that your Lordship it is closed with your direction that I have a liberty to go and if it is crystal, what is the having an effect?
So therefore, either I'll have to withdraw, I'll have to, or I have to dismiss it.
It's a nice action going on for a scan copy, my lord, your Lordship.
Can
What is the
copy
meaning of
nothing will-
calling the scan
Mm.
copies? Because you want a quashing. Initially, I thought that it is only for the, but your prayer is something you made some other argument.
But because in a further investigation also, quash can
That is
be
not
done.
a prayer in here, even in this
If it
petition.
cannot be, if it is prayer also, it cannot be have been done. In a further investigation, previous charge sheet cannot be quashed because it has to continue.
Yes, it is to continue. Your case is quashing.
Uh,
So either you have option to withdraw or option left is to dismiss.
Your Lordship may then give a
Okay, that is with the liberty to avail
the remedy
remedy
under 173.
under permissible under law, permissible under law, including prayer for a further investigation. In the event of such application is filed, the learned court shall pass necessary order
Yep.
in terms of following due process. Your case is quashing
No, no, because
and you are arguing for further investigation.
I thought we picked the ground because
May it please your lordship. The petitioner is the wife of the respondent to lordship who is seeking a transfer of a complaint case filed by the respondent at Margarita lordship. Petitioner before filing with his case lordship, petitioner filed a 120 proceeding as well as a reverse proceeding before the learned principal of family court at Guwahati lordship, as he is the resident of Guwahati lordship. And after notice was served upon the respondent lordship, respondent number 2, that husband lordship, he had filed a complaint petition against the present petitioner at Margarita lordship. So I am seeking
That application under 406.
yes, sir.
What is the misappropriation?
Lordship, my articles, lordship, my gold ornaments and other things, lordship, which as per his statement, lord.
Ah.
Those as per his statement, I have brought back those documents with me when I left the house of the my husband, lord.
Petition number 406, 407. That's part of proceeding. The husband is contesting a divorce proceeding
As well as one.
as well as a proceeding under section 125 pending in the jurisdictional court in the district of Kamrup Metro.
Yes, sir.
Kamrup Metro. And the complaint has been filed at Margarita. At Margarita. Considering the above, issue a notice to the respondent আছে আমার
Order
Is she a party?
Yes, sir. Status.
Respondent number one. It's one.
One.
Accept notice. Two. Four phase. Still returnable. Further proceeding. Strength of subpoena.
deeply obliged.
Transfer on notice order.
Obliged.
Yes, where is Union of India?
We have informed them, your lordship.
A list will be now. A list will come out now.
Lordship.
A list will come out and it will ask to serve it to the in the PSGH office. It was mistake on the part of the registry.
Sure.
And we'll take it after some time.
Sure.
Yes, you are here. Gina.
Senior
Senior Government. Okay. And what about Union of India? Come together. If sanction is there. If sanction is not there, we'll stay. As simple as that.
obliged.
Made please, your lordship.
Hmm.
Here, that case, where a blow was given, person died, subsequently, on the last occasion, the charge sheet was submitted by the landed PP, that's why my scan copy was false.
Yes, it is received. Where is that? Scan copy. There is a note.
Sorry, there's the office not locked.
Copy, scan copy of the search sheet. Spencer, Poliapur, Nagaon. X. That is there X.
So she may take after some time, we'll go through it.
Where is that? Huh? It's called scan copy. Huh? Yes. There is a mistake also. Court ought to have called for the scan copies of the case diary.
Yes,
Now scan copies has come the search sheet.
only with the first.
Only with the search. What is the allegation? Who stated what? Nothing is there.
Otherwise also, case behind the bars for 84 days, and the case is not yet committed. It is still in the court of SDGM, Poliapur,
All needs training. That is the problem. Scan copies of the search sheet. There is a order. How can you blame the magistrate? Registry will call the what to do upload that. No,
84 days, and
Please do please involve.
only one blow, there was no, it was not.
It may be 304 or but to do that we need something na.
Lord,
On what basis we will pass the order?
Lord.
Registry shall again requisition the scan copies of the case diary of
Scan copy of the case diary of the Uloni PS case number 46 of the 23.
from the
Yes.
the committal court, that is
SDGM Poliapur.
SDGM Poliapur.
No.
Is this matter on
811.
811?
Obliged.
May I please, Lordship?
Yes.
Lordship, in this case, the Lordship, I have no role, Lordship.
Lordship, I was arrested under section under one
Oh,
twenty.
that case. How many cases are there?
My lord, from 21 to 32.
Just give us the names of the these persons.
My lord. Whether the other
How many days?
Lordship, 44 days.
Item number 21. What is your name?
Lordship,
Hemonto.
Hemonto Hazarika.
How many days?
Lordship, 44 days.
44. Then item number
28, Lord.
28. What is your
No,
name?
my lord, PK Kolika.
Item number 57.
PK.
Kolika.
For how many days?
44 days, Lord.
So all on the same date.
No, my lord, somebody, there are some person 39 days also.
Okay. And then Mr. Bora,
27.
27. Just a minute. Vishwakarma, how many days? 44. Then item number
29.
29. Somsar. Somkar. $44. And
Then
And?
item 31. Rahul Dekar. 30.
Rahul Deka 44. And 34.
30.
32. Sebu Setri
44.
44. These are the cases today.
Today also.
Give us the case.
My-
Amit Setri. Amit Setri is before us.
No, Lord.
Then Arun Setri is before us.
No, Lord.
Krishna Thapa.
No.
Chunu Bosumotari.
No, Lord. No, probably the my lord main person.
Just I'll recall. Item 31. Rahul Deta.
Yes.
Rejected. Who is for Rahul Deka? Rahul Deka rejected, na?
Yes.
Okay, everybody name Rahul Deka. Anybody Romit Setri?
Lordship.
Huh? Romit Setri. Item number
28.
rejected. Then anybody Amit Setri?
He is not here, fine.
He is not here. Arun Setri?
He is also not here.
Hireshwar Brahma rejected. Item number 30. হেমন্ত Vishwakarma. Item number 29. Huh? Sambhar. Then and Shibu Shetty. Let me see Shibu Shetty. Seen something. Are granted.
Lordship, in item number 28, there are the 4 petitioners.
Tell us their name. That's why I have asked the name.
Lordship, Pramod Pradhan.
Just a minute. Oh, you have said your name.
Yes.
I asked the accused name. Pramod. Then-
Pramod Pradhan, Vishwa Boro.
Again, I'll have to see everything.
Lordship.
Vishwa Boro.
Vishwa Boro, Lordship.
And then
Ramit Bahadur Setri.
Romit.
Ramit.
And
Then Lordship, Binod Thapa.
in item number 21,
28, Lord.
21 granted, na?
Yes.
Amount. 27 Vishwakarma granted. 29 granted. 30 rejected. 31 rejected. 32 granted. Okay. Now come to 28. 28 granted. Rejected. What was and what? How was the name?
Ramit Bahadur Setri.
I said
Yes,
rejected. Romit.
Ramit.
Romit. na?
Ramit Bahadur.
Romit rejected. Others promote
Vishwa Boro.
Vishwa Aru
Binod Thapa.
Binod. Let me see one. Romit is also there. Romit rejected.
Lord.
Huh? In item 28, Romit rejected, others granted.
All disposed of.
All disposed. All disposed. Arita line will take over. From the case diary, it is seen that most of the person beyond this accused also named also named specifically one Amit Setri, one Arun Setri, one Krishna Thapa, and one Gunu Bosumotari as the main culprit in this case. In as much as the learned additional public prosecutor on instruction from the IO submits that these persons are absconding and are influential persons, and they are every chance for influencing the witnesses. He returned back.
All right.
May I please the Lordship? I look for certain application and petitioner arrested on 15th September. 33 days he is behind the bar, my lord.
Where is the affair?
Page 13, my lord, the Carnegie Lord. and extra one.
Yes,
13, 1 3.
My lord, it will not, may not come out with 376, it will be a case of 354 from the 160% of the victim.
what is the age of your client?
My lord, my and 49 minutes.
Huh?
49.
Very bad.
Even he has also confessed.
Hmm?
He has also confessed.
Very bad. How many days?
33 days.
It should be an attempt,
Attempt, because the 376 will not come out. 354.
but it should be an attempt.
Yes, sir.
Attempt, what is the punishment for attempt?
It will be around 60 days. Sir. 5 years.
What you say?
Not less than 1 year, but extended up to, can be extended up to 5 years.
Okay, considering the period of stage, period of detention and stage of bad case, we feel bad to give this kind of people bail.
Plus,
You understand? Support. Yes, Munir.
Lordship, KJL was called for Lordship. 304B Lordship, the item 23 is the husband and Lordship 24 is the father-in-law and mother. So that is
What is the
430.
affair?
430.
No, so last occasion we received the case diary Lordship without the postmortem report. Now today also Lordship we have not received the postmortem report.
How many days there in?
My lord, the accused in item number 23 was 33 days Lordship, and other item number 24 is the AB Lordship. There are father-in-law and mother-in-law of the victim. This is about.
What a postmortem report says.
That is not received.
When?
It will be after vacation only now.
3110 or 211. Vacation when?
Holiday Lordship at one.
Vacation.
Vacation.
Reopening Lordship.
Reopening. On reopening. Till then, it will be easier for you.
My lord.
811. 811.
My lord, we return the case there, Lord.
Yes.
Much obliged.
Though case diary, if the postmortem report is not yet received, accordingly, case diary be returned back and be produced on the next day 6 along with the postmortem.
Much obliged.
I am appearing on behalf of Mr. A. Ali, my lord. City was called for.
Medical legal report.
25 case there is no received. Reopening.
Okay. Reopening. CD when?
1411.
14. Yes, Vishwas,
54 days, my lord.
what he did.
He has struck a blow on the head of the informant according to the allegation. And he got some speeches, and on the same day he went back home.
How many days?
On the 55 days, Lord, we have received the case diary without the injury report, Lord.
Considering the detention.
Chief Judicial Magistrate Kamrup,
Chief Judicial Magistrate.
Amingaon. MD.
Hello, Lordship was pleased to call for the scanned copy of the charge sheet and
We'll take up this. That is kind of is here. Borua, go through it. Whosoever you go through it. If necessary, you can also go through it. No problem. And then you assist us. Because from the one report, police report, I think there was no injury as such.
Yeah.
If no injury, only apprehension, the seizure.
actually there are some injuries, very old injuries.
That from the
Very old.
bail order I have. Okay, you go through it. We'll take it as per law.
Yeah.
We are not being swayed away by
Any other content.
And another matter is, dear Mr. Choudhury.
Yes, that last item, Lord.
What will you do that? Will you fight before it or will issue a notice? Not say. That is better, I think. Before you fight, before vacation.
Okay. Notice on stay.
No, notice on.
Fine.
All inform your senior. We will not interested in a fight between these two stalwarts today. Before I think they are going through it after some time.
I think we have seen it.
Yes, well, otherwise, direct medical report I have not found, but the statement of the doctor are here. I also remember from the city, 13% burn injury and some total. I have marked this one statement.
In any case, by now, today is 39 days.
What, where is the, okay. Victim statement. We have not marked it.
Well, in the first,
That first flag, I think, yellow.
there are two guns.
No, this is a search sheet. No? Written sanction. Okay. What is your case, Mr. Chaudhary?
My lord,
What will you argue?
my case is basically, my lord, the injury report is not very specific. And there is an allegation that hot water was poured. But my lord, there is no allegation that there is no, allegation from the point of view of
What is
victim.
your investigation? Suppose what is your investigation? Where is your medical report?
Yes,
My lord, that I'm going through.
Where is your medical?
I'll
They are,
tell you what has happened.
my lord, I have this-
medical reports are not like this. You'll have to
Yes.
mark it, what
Yes.
inch, how much.
Yes.
Yes.
And my
Is
lord,
it the investigation?
my lord,
So see, otherwise the allegation made by the victim is it's unbearable if it is true, and it is not expected from a
Correct.
person of your stature.
Yes.
That is, you'll have to also agree.
Yes.
But what so much hue and cry? Where is your investigation? Show us.
There's another gun
This is the difficulty.
out of
in fact, yesterday Allahabad High Court had acquitted the two.
We are frustrated looking at the investigation. You know that this has been done, but you cannot convict because of the investigation. 30% burn injury. What burn injury? Superficial, depth, which place, what is the measure? Is it a way to do?
And the, my lord, victim statements also does not reveal that immediately after pouring of the water that she had to be given treatment or that nothing is there, my lord. Eventually the conclusion is 30% burn.
So therefore, her allegation is that after she informed, whether you have recorded statement of the Duori, tell me. One Duori,
That could be
Duori statement. Tell us, because according to her, she informed the Duori. I think he is the leader. So that Duori is a public representative or what? I do not know. Now he rang her, this officer,
Ex-MLA.
ex-MLA. He rang up this person. Then if that be so, and she was agitated because of that, and therefore the torture. Now where is his statement? Tell us, and the medical report. Huh? And what about medical?
Medical, you know,
Or you can take it after some time, Mr. Chaudhary. Your argument is that much, and
Yes,
we'll
yes.
see the CD and take a call.
My lord,
Two things are in our
I
mind.
followed that, I followed.
And
Only
other
thing is,
part
my
is
lord, in any case, my lord, I'll face the trial.
trial.
39 days, I'm already
Already,
inside.
that will be your
And I'm
argument. But
already
another
present.
another aspect of the matter is that whether at this stage, before her examining, you may take a chance. This is all. These are, we have not taken a final call.
Followed, my lord.
After her examination, that there may be a thing. The way she has explained vividly the situation that disturbs the court, mind of the court. We are also human beings.
No, followed. End of the day, we are also human beings.
Yes.
We all are human.
Okay, you can.
My-
We'll go through it and pass
My-
pass out. You just help me with the things. That is specific query.
My only thing
And-
is, my
and-
lord, damage is already done. I am
Done.
suspended
That's done.
40
that's
days
done,
behind the
that's
bar. I'll face the trial, my lord.
done. Okay. You
Hello, hello.
give it to us.
Hot water pumping image. 13%. 13%.
There are some photographs. These are very, very bad. And as per her description, that is there. But whether the doctor has stated in his report.
Well, actually, what has happened, he, after pouring the hot water, he was locked inside the bathroom.
Understand. But
And he
then
like-
also there will be some mark that these are the square. This inch into centimeter into this. Is it the way of doing investigation? Yes, Mr. Pukan.
Those are not done. It's very general.
See, so much hue and cry, including the Honorable Chief Minister intervened. And this is the way you do in investigation. What action will you take against this? Can it be a report of a doctor?
Well, there is one report, another report.
Yes, to us.
Initially, she was taken to Joysagar Hospital, civil hospital, because it is a burn
And so
injury.
was the Duori statement.
I have marked it also.
Yes, okay, we'll see and we'll
My-
apply our mind. We have not taken a decision as such. Let us see.
There are two medical reports.
Yes, you just flag mark it?
Yes, I have.
Okay, next case, next
Fine.
case.
My lordship. Lordship, city was called for today. It is the fifth time, your lordship.
Yes,
Since August, your lordship. And on
Pukan, you should be careful. You should lead this
My lord.
system. In many cases, we have seen. See, in some cases, since you are here, there are allegations of bond. That 306, 307, all those are there. The victim is alive for 5 days. I have seen in 3 cases. No statement of the victim during this period.
I am also come across many cases. The
So
victim
if-
statement was not recorded by the doctor,
Hmm.
nor the IO,
I
nor the nurse.
even in a case, she was from Dhubri to JNRC, not even visited JNRC.
Right.
Because the moment a person is admitted in a hospital, there will be a medical history,
Right.
more particularly in this burn injury. And how this hospital is not informing the local police station that this is a burn injury. There is a mandate.
Right.
In case of burn injury, more particularly in case of female, they must inform immediately.
Right.
It there may be allegation,
Yeah.
there may not be allegation.
Yeah, the executive magistrate may present at
Yeah.
point of time regarding the recording of statement.
Yes,
And moreover, the relative extrajudicial confession may also be accepted. That also do not record
not.
police.
Even the nurse who treated,
My
she
lord,
may
yes.
say that
Yes.
this is how it
Their
has been
statement
done.
also not available in the record. Right?
Nothing.
There by the thick form.
And there will be hue and cry.
My
And
lord,
after acquittal, it's blame on all on the court
yes,
because,
correct.
and for whose fault these are being done.
There are 6 forms of my lord, the bond. Not a single statement we have record in which stage this burning was found.
This is the case you see.
And even my lord, the 90%, 100% bond also my lord, they can be my lord in a speaking position.
Yes.
Yes, yes.
Burn injury, if it is a speaking. Yes, what is this?
Please, your lordship, CD was called for your lordship. Not received, my lord.
What is the allegation against you?
Allegation, your lordship, page number 12, your lordship. There were 2 FIR, your lordship. At first, your lordship, the FIR was lodged on 24/7, your lordship, 24 to 2022, your lordship, that the petitioner has kidnapped a girl, your lordship, the victim, and thereafter, your lordship, in that case, the petitioner was granted bail, your lordship, and your lordship, that case is on trial, your lordship.
No.
Your lordship, again, your lordship, the father of the petitioner, your lordship, he has again lodged an FIR, your lordship, that the petitioner has kidnapped the victim, your lordship. They were in love relationship, your lordship. And on the day, your lordship, when
Problem is that in this country, to elope on the basis of a love relation, you must attain an age.
yes, your lordship.
That age you have not attained.
Actually, your lordship, we did not elope, your lordship. Your lordship, my page number 23, your lordship, annexure 4. Your lordship, on that day, your lordship, I was in hospital, your lordship, after consuming poison, your lordship. And
Oh, you went to consuming poison also.
yes, your lordship, because of some dispute, your lordship. Thereafter,
Dispute with the girl.
yes, your lordship. Thereafter, the girl, she himself came to my house, your lordship. Thereafter, the allegation
How
was
many
that
days you are inside?
AB, your lordship. And today it is 5th time, your lordship, that CD has been called. Since August, your lordship. At least
What is your age?
my age, your lordship,
23 years.
23.
Sirajul Ali. And what is her age?
Her age, actually, your lordship, they have stated 17, but it is more than 17, your lordship. 2 FIR, same allegation, your lordship.
Yes. What to do?
CD not received, I mean, not in a position to take it. At least I may be protected before Puja, your lordship, later on.
She should understand that until and unless she is 18,
She went to my house.
her coming to your house will create a problem for you. Earlier, you were inside there,
Yes, your
you had to have had to eat poison,
yes, your lordship.
consume poison. Okay, case diary call for is not received. Peruse the material available on record. The petitioner. In fact, the moment you say that you were earlier also arrested, you are not even entitled for intent. Okay, give a early date, 19.
19.
19 will try.
19.
Bring the case date, 19. Case diary 19. Please
Yes.
call it or we'll call the IO.
Yes.
If case diary is not produced, I will personally remain present.
Till then, your lordship. 19 for
What till
okay.
then?
Okay. Obliged.
It was called for matter. For petitioner number 2, 3, and 4 concerned matter, they are in interim bail mail. For their statement mail. Here, the FIR lordship will find at page 14 mail.
This is
34.
Page 14. After incident of 2018 matter, now matter, in the year 2023 matter, this FIR has been lost matter. Everything matter, offense under section 50.
that's all. Yes, tell us. You're on interim.
2, 3, and 4 an interim, my lord. Petitioner number 1 is not an interim, my lord.
Uh,
2, 3, 4 appeared and recorded the statement, and the allegation is mainly against petitioner
What?
1.
So one is rejected, 2, 3,
1,
uh,
4 also implicated.
2, 3. That is
Brother,
Zahirul, Parvina Sultan, and Abdul Hasim.
so here, my lord, kindly
They
see,
are
my lord,
entitled.
kindly see, my lord, FIR is at page 15, my lord. Here, my lord, allegation is done, my lord, with the allurement of marriage, my lord, physical, established physical relation, my lord, that to my lord, in the year 2018, my lord. Page 15, my lord, third. Then second place, 2018, my lord, now FIR has been lodged in the both are measure. Petitioner, here, my lord, petitioner for lordship, petitioner number 1 is, my lord, mental patient, my lord, I have annexed his certificate.
Petition number 1 is.
Mental patient, my lord, underwent medical treatment. Page 10, my
Well,
lord.
as per
Oh, your mental problem will.
well, as per the other petitioner, one of the petitioner statement, the petitioner number 1 is now working outside Assam.
Some problem is going on. Even then, my lord, it's a incident 2018, my lord, both are measure,
Girl,
my lord.
girl is a handicap girl.
In the year 2022.
What do you do?
I might not, my profession,
What is your profession?
my lord, daily wage labor.
He absolute. One rejected.
It's a incident of 2018.
Maybe.
After 5 years.
Certain cases we are not happy with your conduct. You may say discharge the relation. Go upstairs. He has even given you money out of love. Got government sanction as he was a specially able person for money, and you have taken advantage like anything. Yes.
This is your lordship 438 application. Allegation that is of lordship 302. But lordship, as per the instruction of the petitioners before your lordship, at the time of incident, their menial vegetable grower and sellers, they were outside, they were not present. Lordship, the FIR at page number 10, my lord, allegation is that the deceased had come to do some local medicinal work, lordship, Kobiras or whatever, which doctor one might say. He was called to treat the ailing son of the FIR name accused number 2, who happens to be the sister of the present petitioner. Now this deceased has come, and during this witch doctor.
Just a minute. Why just written up?
What had happened is that
when he went for that quit doctorate thing, he lordship molested and the outraged the modesty of this FIR name accused number 2 in the name of some her medicinal procedure.
Noor
On
Nehar.
Noor Nehar, my lord. Noor Nehar, and on that instance, my lord, Noor Nehar, number 2 and number 3, who happens to be Noor Nehar's husband.
Number
These two-
3.
Number 3 is Noor Nehar's husband, and both of them has been arrested as per my instruction. So these two persons, along with local people, when hue and cry raised,
And
then possibly he was
what is
assaulted.
your name?
My name is my lord Amir Hamza and Mustafa Alam.
Yes, what is their role?
Well, so far, after going to the city, my lord, I have found material against this Mustafa Alam.
Okay.
Regarding this petitioner 1,
So you just mark it.
yet I have marked it.
Mustafa Alam is petition number 2.
Petition number 2, my lord.
Handwriting is very bad. Other.
Huh?
Handwriting is very bad. They saw Mustafa Alam beating victim. my lord.
You cannot. So according to you, Mustafa Alam is yes. Musidul Islam. Who is Musidul Islam?
He is not before your lord.
Not before. And Mustafa Alam, he is before us.
Mustafa Alam is before you, my lord.
Petition number 2.
Petitioner number 2.
Petitioner number 2 rejected. Petitioner number 1 granted. Appear before the IO recording.
Quite good, my lord.
Okay.
Deep
CD
document.
returned back. There is specific application. Commission of the offense against the petitioner. Considering such material, this court is not inclined to grant him privilege of clear escape. However, no specific material against the petitioner number is number 1 is found in the case diary. Accordingly, the prayer for clear escape so far relating to petitioner number 1 is not subject to punishment.
Deep document.
37 PT not.
Rejection, my lord. But one thing ground is part of the fertilizer 200. We admit part of it. 79 411. Nobody has come into. I admit it is my EMI. I have purchased locally. And it is loaded from my house, madam. I also admit. Only my receipt, normally it is not available because this it is not a
Okay, have the city.
My lord, let it pick on 19 will try from board.
problem.
Piece 19. Piece 19.
This thing.
How many cases you have fixed we do not know on 19?
These are from nearby places.
May I please ask?
Yes.
430 application.
Yes.
Second time application launch earlier as a respective lordship because some witnesses implicated my name lordship. Now lordship
Where is the FIR?
FI is case number 15 lordship. Registered under section 379, 279, 302 and 34 of the IPC. And if lordship reduce the FIR, it's in every line lordship. This is not a case of 302 law. It's a complete case of accidental case.
Where is the earlier order?
At case number 16 lordship.
This is not a case of accident.
Not
You try to fly away and in the meantime you hit this person. on the road.
279 and
To
302.
save your life,
in-
you have killed other. 2 person, na? 1 died.
One died. Two died.
Two
2
died.
died.
Two died.
And my driver is also died.
for your thing, 3% unnecessary.
Husband, wife, elderly
Husband,
people.
wife. It may not be murder, but the purpose of intention is not here.
But it will
But it is
trial murder.
heavy.
Maybe.
Lordship,
Go there and come back to us. On the day one, we'll give you. We are rejecting it. Go and surrender and come back. We are giving on the day one.
because I am the Lordship placed it over Lordship. I was not even there at the place of occurrence. Lordship.
You have allowed to use the vehicle.
I have a rental Lordship, business Lordship.
No,
I-
you are there. He was there.
Yes, there. That's why I,
Yeah.
otherwise I would not have.
Belong to his partner.
What is his name?
Kuldar.
And the Quddus and Zakir Hussain Lordship was also not there Lordship. He got picked up by the police Lordship, investigation officer Lordship. After the cause of occurrence.
$10,000 rand.
This is not the first time.
This is not the first time. 10,000 rand for an vehicle is a vehicle where people will not suspect that cattle is smuggled there. It's an eco-sport.
Recently, I came across a case where I-20 was. Well, I-20.
It is taken for grant of free arrest date in connection with mental illness. After perusal of the case, the court earlier rejected the bail. From the material available on record, it is seen that the offending vehicle which was involved in the incident belongs to the present petitioner. And the said vehicle has continuously been used for stealing cattle with a rent of rupees 10,000 per day. And the vehicle has been used on many occasions. However, on the fateful day when the villager could learn about the attempt, could learn about the stealing of cattle, they tried to block the vehicle, and in the process, the driver of the vehicle, namely Sofikul Islam, drove the vehicle in a very high speed and hit the two persons who died subsequently. Considering the continuous involvement of the petitioner by in aiding and the aiding considering the continuous assistance and involvement of the petitioner as discussed herein above in commission of offense on many earlier occasions which is available on the case diary. This court is of the view that the petitioner being habitual offender are not entitled to for privilege of pre-arrest bail, inasmuch as no new ground is available. Accordingly, the bail application, prayer for bail stands before.
Forty and 41. 40.
Yes, where is the
Lordship, kindly take 41 first, my lord.
41 part?
My lord.
It is Puya and Gogon Boisha.
Gogon Boisha. 41, my lord, an application
the
under
affair?
section, my lord, on page number 11, my lord. Application under section 439, my lord. My lord, may I read the affair?
Yes.
Subject complaint regarding attempt to murder of laborers Mr. Nor Ojit Sheikh and Mr. Meg Bahadur Rai at 1:30 a.m. at Akashinagar, Pamuni Moitam by miscreant Len Mafia, Mr. Gogon Boisha, Mr. Hitesh, in association with his friend and accomplice. Respected sir, myself, Dr. Junmoni Borgoi, gynecologist by profession, presently residing at Rihabari, have a residential plot at Akashinagar, Pamuni Moitam, where I had hired workers for construction of another new house. For past 3-4 months, Mr. Gogon Boisha has been trying to cohere and convince me to sell the plot of land, as according to him, we will not be able to construct anything, God knows why. I was not willing to do so, and in this process, I tried to make him understand and reason with him that this was illegal and he should not do such thing. In the meantime, another friend of his, Mr. Hitesh, also come into the scene and kept on that I should meet with them. Due to persisting, I agreed to meet them and sent a WhatsApp message to Gogon Boisha for setting the time of meeting. Mr. Gogon Boisha called me and we agreed to meet at 5 p.m. of 15/9/2023, venue decided by me as Starbucks Zia Street, keeping in mind security reason. Previously, I had donated rupees 1 lakh only by transferring to the account of Gogon Boisha as requested by Gogon Boisha for welfare of their club and Namkar. But this time, with Hitesh demanded huge sum of rupees 10 lakh to 15 lakh, which I considered to be extortion and not donation, as I become suspicious as Gogon and Hitesh was never accompanied by other club members and hence denied, following which he certainly gave message that it was not a good sign. I tried reasoning with him. This was absurd and illegal, and us being neighbors, it was uncalled for. Following this, they on and off went and asked the laborers to stop working and stood. This message was conveyed by labor to me. When I consulted about this issue with another person, they suggested we should not worry. After all, they were working within our own premises. Never in my dreams had I thought that young Assamese boys could be so malicious and heartless with murderous intent to have sneaked in at night 1:30 a.m. of 19/9/2023 and suddenly attack these sleeping laborers and beat them up so mercilessly and bezaring them and hit them in all possible places of body could lead to major trauma to vital organ and be cause of death for no fault of theirs and leave them to die. As stated by the injuries, when I examined and asked for the gravity of their injuries, they were hit by sharp and blunt sticks, 10 fan LPG cylinder, etc., mainly on the face, head, and chest and abdomen, with every intent to kill. God save them and be with them. Luckily, one of them was able to dial my number and say, "Baidew amak bahut marise, Rai mata nai," and rush to their place as early as possible. Call the name care ambulance on the way to save time, but as Rai unconscious,
I did not wait and transported all of them in the backseat of my car and reached Nemcare Hospital emergency at the earliest. First aid was given, CT scan and X-ray done, wounds that were bleeding profusely and deep and gas.
Yes, what is the metric?
My lord, the affair says everything, my lord. It is supported by the evidences, my lord.
My
Like,
lord,
it is perhaps, my lord, Lordship,
How many days, Gogon?
my lord, Gogon was for 28 days. My lord, I beg to the honorable court's kind
perhaps,
attention.
my lord,
At
28
that
days may
particular
not be
time, my
enough,
lord,
my lord.
at that particular time, my lord, point of time, Gogon Busta has undergone a major operation on his shoulder, my lord, some days earlier, and he was at rest at that time with bandage and plaster in his hand. My lord, forwarding report is clear with his picture, my lord, which was appended. Kindly see, my lord, page number 28. And my lord, I have
Get
annexed
treatment
medical
inside,
document,
no problem.
my lord.
What is the medical report?
My lord, medical report, it was, my lord, a reminder issued, but it was not ready. That is why it was not provided, my lord. This is the notice there. And some photos were annexed with it. That photos will speak of everything, my lord. My lordship,
What is it?
there is a statement of the, my lord, Gogon Busta that will speak of everything, my lord. We understand that they might have something with the owner of the land, man. But what is the, my lord, fault of those laborers, man? They were mercilessly beaten at 1 p.m. 1 a.m.
These are, I think, land brokers.
Yes.
My lord, Gagan Busta was not there at that particular point of time. He was in rest, my lord. Kindly see the forwarding report, my lord, which his photo is appended by police, my lord. And I annex also medical report, my lord.
Be under treatment in the hospital, in the jail. What is your problem? At the government's cost. Why you spend money? We'll say that give him proper treatment.
My lord, as per my instruction, Gagan Busta was not at the place of occurrence. As per my instruction, my lord. As because he was undergone that major operation on his right shoulder, my lord. Some days earlier, my lord.
When the incident took place?
On 19/9, my lord.
19, my lord.
You made it an accident 1 month ago.
My lord, but I undergone a major operation, my lord. My right shoulder was under plaster, my lord.
You released on 18/8.
My lord.
15/8 accident, 18/8 discharge.
My lord. But my lord, my plaster was not opened, my lord, at that particular point of time.
When you
I
may
may
be
not-
standing and asking your goons to beat them up. Not necessary. You are a don. You can call the others to beat them up. Be under government's care. Give him treatment.
Lord.
If necessary, give him treatment.
My lord, length of detention may not be considered, my lord. 28 days, my lord.
Injuries are serious injuries. Allegations are serious. Again, he will try to grab that land. Case there produce heavy. Huh? Heavy. Also Perus, this injury report is not there, no?
The report is not there, my lord. It was false.
Perus, the photograph of the injured victim, though injury report is not
And also, my
available.
lord,
on the
statements of the victim.
Huh?
Statement of victim.
Also, Perus, the statement of the injured victim who has specifically implicated the present petitioner as well as one Gogon Boishya one Gagan Boisha in inflicting the injuries upon them. Full stop. Considering the material so far collected by the investigating authority, comma, this court is of the view that petitioner is not entitled for privilege of pre-arrest bail. Accordingly, the same stance rejected. Created Namtur is a specifically alleged the present petitioner in commission of the offence injured victim of and along with another case via considering the stage of investigation, this court is of the view that further interrogation of the present petitioner may be necessary. Therefore, the prayer of bail is rejected at this stage.
Obliged.
Yes, sir.
Obliged. CD were not received.
Yes, Muhammad Ali, what did you do?
I am the owner of the pharmacy, Lordship.
Then
At the time of incident, I am not present at the court.
what was the incident? First tell us. You are an owner of the pharmacy. You were
FIR
not present at the incident. But what is the incident?
FIR at page 12, Lord.
Tell us that part. It is not important for immediately. Page
12. Parnagula.
my goodness. You are a doctor or what? Huh? You are a pharmacist or a doctor?
Perhaps madam may not be a pharmacist also.
You are Muhammad Ali.
Yes. He gave the injection.
I am the owner of the pharmacy.
Hafizur Rahman gave.
What injection did you?
I could not put the injection. At the time of occurrence, I am not present at the pharmacy. Accused number 1.
What is the postmortem report?
My CD we are awaiting. My that is.
Did you?
Okay. Required. My
Case diary call for is not listed accordingly. Method sense adjourned and be listed on
13. My
13/11.
31st. Okay. Vacation code.
Just have it. Why this person that? What kind of injection?
Yes, but he
Really, where we are taking?
my 43 my before landed and start my a case of 2017 my but my the injury report two things are there. One is 326 and 376. 326 comes when my lord when he visited the police station, victim visited the police station and registered a case against them. While coming on the way, they were beaten up and my lord, and that is how 326 come my lord, and 376 the allegation of death.
My lord, now the victim and the accused number 1 living as husband and the wife, my lord, I have annexed on affidavit, though the case is not combinable, my lord.
File a crossing petition.
That I don't know.
We
my lord.
consider.
Subsequently, I will come under 482 for crossing.
Come up for 482.
My lord, at this is page number 13, my lord. To given an affidavit, my lord. Perfect, there is no injury report.
There
There was no happened any market. Initially, both the petition and the petition number 1 were in love, and my lord. The
Where is your
petition-
statement?
My lord, affidavit is at page number 30.
No, affidavit we have seen. Where is your statement
My lord,
Regarding
in the petition?
my lord.
To us.
My lord, page number 4, para 5, my lord. That the petitioner begs to issue the accused petitioner are innocent persons and they are in no way involved with the alleged offense as alleged by the innocent part of practice that the accused petitioner number 1 and the victim were in love, and the victim persistently demanded the accused number 1 to marry her within a period of 1 month, but the accused number 1 and his family
Hard-
member.
Case diary call for is not received.
is there similar but without medical.
What is her statement in the case diary?
Her statement, my lord, is specific
That is of 1942.
1942.
Now we do not want 1942 statement. We want recent statement.
Recent,
Okay.
recent,
Okay.
we can update.
Heard the learned counsel for the petitioner. Also heard the Mr. Goswami learned director for petition application of the file. Case diary is produced. The petitioner produced and perused and statements of the victim were recorded on
164, it is at the time of my lord on 25th July 2017.
25th of July 2017. Full stop. A specific statement is made at paragraph 5 of the petition that there was a love affair between the present petitioner and the informant victim, and due to misunderstanding, the affair was lost, and subsequently they got married, and presently they are living as husband and wife with their children. Children. To that effect, an affidavit has also been annexed with the present petition. As annexer,
My lord, annexure 2, page number 13.
as annexer 2, peruse the same. Considering the subsequent peruse the same, the such affidavit has been shown before notary public on 13/9/2023. In view of the aforesaid development and statement, this court is of the view that the case diary is required to be updated and a fresh statement of the victim is required to be recorded. Full stop. Accordingly, it is case diary be returned back and be produced after updating the same.
No.
Considering the nature of allegation and the statements as discussed herein above, it is provided the petitioner is granted interim bail on the following conditions: to appear before that, make a statement, and this affidavit original produced before the IO.
Appear along with wife.
Yeah,
That it will be
You go along with the wife
wife.
and get your statement.
No, my lord.
Okay. Interim.
On my lord, 27, my lord,
27.
Highly.
27/11.
Highly.
Where is Bothaur? There is some recent judgment,
Lordship,
very recent.
on sanction.
On
Okay.
this UAPA.
I have brought judgment, your lordship, not on sanction or not on UAPA. Tata sanction.
Tada.
Sanction. Perimetry provision, your lord.
But UAPA there is a, I think, recent judgment. Anyway, you proceed. What
Lordship,
was the provision?
Section 45, your lord, of UAP.
Just a minute. Let us see how Digital India works. 45.
45. No court shall take cognizance of any offence under chapter 3 without the previous sanction of the central government or any officer authorized by the central government. 2. Under chapter 4 and 6 without the previous sanction of the central government or as the case may be the state government, and such offence is committed against the government of a foreign country without previous sanction of the country. Sanction for prosecution under subsection 1 shall be given within such time as may be prescribed only after considering the report of such authority appointed by the central government or as the case may be. The state government shall make independent review of the evidences gathered in course of investigation and make recommendation within such time as may be prescribed.
Yes,
This is your
according to it, there is no.
sanction that is admitted by the from the
We will examine it. Huh?
I'm proceeding.
You are the sanctioning authority. Mr.
My lord, I hope your lordship is not passing any interim order.
I'm passing an interview.
In that case, my lord, I may be
Yes.
given an opportunity to. My lord,
You will say Sai Baba's case sanction on the basis of the sanction, they were acquitted. It went to Supreme Court passed and stay. Isn't it?
but I have another case, my lord.
Yeah.
Where sanction is not there. Cognizance taken, trial held, trial court convicted the accused person. High Court discharged them on the ground that there was no sanction. This is, my lord, state of Maharashtra versus Mahesh Kariman.
That is DN
Okay.
Sai Baba.
Jain Sai Baba.
DN Sai.
That is Jain Sai Baba.
Yes.
Jain Sai Baba's case, it is still not decided.
No.
Not decided.
It is a case, the famous case of taking on the day one,
Right.
and there was a stay.
But
But issue is not decided. If we go to
But that-
so far relating to PC Act, Najappa versus State of Karnataka,
Najappa.
2015. Are you having that?
I have not brought it to your but Najappa.
That says that any state, it will have to, it's a mandate. We will examine it. We will have
No,
to
no, no,
examine it.
may I stop you?
Because so
Lordship may-
far relating to the Sai Baba's case, that is a interim order that has not been decided by the honorable apex.
But in one
Ultimately,
important,
Your Lordship,
my lord,
that is an interim order, and when the final order is passed, leaving
And-
all issues to be taken up by the learned Honorable High Court, Your Lordship, matter is remanded back.
Yeah.
No final decision.
no, Lord, why am I submitting? My lord, yes, interim order, that is all right. But one important question of law is, my lord, posed in that case. My lord, whether the right to protection under section 45 of UAP Act, my lord, is absolute, because the provision of section 465 has diluted that right. Because on the ground of 465 of CRPC,
Okay,
that question is not pending. my lord.
no, that question is
Now-
pending, but question is, this is a special act,
I understand.
not a general act.
I
It's
understand.
a special act, and the provisions, more the provisions are stringent, more the adherence to the procedure.
Yes,
This
that is
the
why,
best
that is why such protection is given. I understand that.
And therefore the protection is given.
No, no, that is
And
why
if
what
you
I,
want to proceed, you ought to have done it. Why so hurry? Because that is the problem with the prosecution.
that I understand, my lord. But
Everywhere we are looking at, prosecution is having all kind of handle to do things properly.
Right.
But they are not doing it. What to do? We are a court of law, we'll go by law only.
no, may I suggest one thing? Sir?
Yes.
Honorable Court will
What kind of
certainly,
interim order are you expecting?
Lordship, that the proceeding, Your Lordship,
Against you,
Lord-
not against others.
may I suggest one thing? My lord? Let the matter be examined. My lord, let it be fixed immediately after vacation.
Vacation till then
My lord,
will post the
Till then, my lord, my lord, if my lord, no stay is granted, my lord, no interim order is granted, my lord, heaven will not fall on it.
no, Your Lordship.
My
It
lord,
will fall. Why should,
My lord,
suppose it's a mandate.
It is a matter of 2 weeks.
Let us see section, let us read the section 45. Because more the stringent, these are very stringent acts. No court shall take cognizance of any offense.
No, that is why, my lord, I am suggesting why LCR is required here.
Who will
He has
call?
not, my lord, the petitioner has not annexed the order taking cognizance. There is gray area. I do not know what is, my lord, recorded in the order of
How to
cognizance.
answer it? You said
Page 89, your lordship may kindly see. There will have to be a finding by the learned session judge that there is sanction. There is a specific ground text.
Session judge does not categorically say that there is no sanction at all. There is no
That the
sanction at all.
learned advocate for the accused submitted that in the charge sheet is a come to the prosecution fact has not yet been obtained. Therefore, the cognizance of this case by the court is not proper. It is also submitted as so far material against it, that is second part, your lordship. Now, your lordship, that is our specific plea. And the honorable court relied on your lordship a judgment, your lordship, which relates to default bail, your lordship. And there is no finding, your lordship. When our specific plea is that sanction, there will have to be a finding. On that count, it's
which paragraph?
Your-
Which
page 89, your lordship. First, second, third, fourth, fifth paragraph. The learned advocate for the accused has
Just start 7.
Lordship.
Page 89.
The learned advocate for the accused has submitted that in the charge sheet it has come that prosecution sanction has not yet been obtained. Therefore, the cognizance of this case by the court is not proper. Your lord. Then your lordship. Then next page, your lordship, the finding of the court. Reported in criminal appeal number so and so, it is held that accordingly sanction is the duty of the sanctioning authority who is not connected with the case at all. In case the sanctioning authority takes some time to accord sanction, that does not vitiate the final report filed by the investigating before the court. Section 1750 of the CRPC does not speak about the sanction order at all. Section 167 of the CRPC also speaks not only about the investigation, not about the cognizance of the magistrate. Therefore, once a final report has been filed, this is the proof of completion of the investigation. If the report is filed within the period of 180 days, 90 days, 60 days from the initial date of remand, accused concerned, he cannot claim that a right has accrued to him to be released on bail. That is not our case, your lordship. Bail or want of filing of sanction order. Section 175 of the CRPC, of course, requires all documents and relevant access thereof the prosecution proposal rely on accompany the final report. Sanction order cannot be brought within the
This is important.
brought within the category of those documents contemplated under section 5 of section 173 of CRPC. The grant of sanction is altogether a defined act to be performed by the government under section 45 of the UAP Act. Now, your lordship, where is your lordship where have the learned court below deal with our contention, your lordship? And your lordship, there are
We'll come back at 2. How many matters are there? Bails are over. Only quashing. Nothing will not. Yes, quashing and hearing.
My lord, with respect to the item number 25, my lord.
That bank matter, madam.
Ah.
Similar order, that person was branch manager. These persons are other my lord designation, my lord. In the order, similar order, passed for the same designation has come. So one IA is filing my lord today. Tomorrow,
Bring it.
tomorrow, my lord.
Tomorrow.
My lord,
Okay, I in fact, while signing this order, I thought, how can it be so similar?
Exactly, my lord.
But you said that exactly same.
No. Exactly. I said the similar order is there. Stay part I just. Anyway, my also mistake I could not clarify.
Could not clarify. Anyway, yes.
my lord, item 50 some urgencies, there police is behind me, my lord. So kindly it will be taken.
Item 50.
50.
50. Okay, we'll take up it. Yes, Mr. NNB Chaudhuri. Where are you here? Yes, Arunachal.
It was mentioned today by the number 9. It has been allowed for because of the appearance tomorrow. The order is
Okay. Okay, first bring the forest matter. First.
My lord, without troubling lordship too much, look, there is a finding of a district judge that the royalty was not paid as regards the Greek art, which comes under the schedule. So my lord, we'll retain that, what I propose, my lord, we'll retain that whatever material was there. Lordship can direct recording of objection.
Material you can retain.
Yes, Lordship can direct record of objection for objection's sake, my lord, and Lordship will release the vehicle.
Okay, we'll release the vehicle.
Retain
But
that.
whatever forest material is seized from the
Oh.
vehicle, the forest department is permitted to retain it
And-
by following due process.
Yes,
You have
fine.
to, you seize it.
Yes, and also my lord, record my objections regarding the vehicle.
That
my
will
lord.
be a
My lord.
serious objection.
My lord.
Huh? AJT to follow photograph signed by two and the forest material which has been seized.
Ah.
uh, uh, Forest materials found in the vehicle can be retained by the forest department by forest department.
All right, obliged.
Or you are a special public prosecutor?
Well.
Forest. Yes, any short matter?
19 euro.
Yes, please. Because,
19. No, no, that means
because I think honest Das will have a serious judgment. That's why we'll hear it a little bit later. Yes, yes. What is your
Lordship, the judgment has been passed by the trial court under section 498 and 326, your Lordship. And I've been convicted for 1 year.
convicted for 1 year?
1 year, and if default in 1 month.
Appeal admit or and I
Yes, IA is 1014. I'm
I-
working as a army officer.
dispose of. Huh? You are on previous bill?
No, first,
No, no.
no. It's the first.
No,
1 year. You are,
Bill.
He's in the previous bill. No, this is the first time I appear before the
oh no.
Previous bill.
trial court. Yes.
When
Yes, yes. In the
you are 1 year, definitely you will be on a previous bill.
He's in working as an army
Oh, we
But-
understand that.
trial. That
You are on bail as on date.
let me. I propose IS criminal 1014. I may be allowed to go on bail. I have already filed an application before the trial court that I will. But unfortunately, bail has not been. No, not in there. Yeah, I'm not in jail here. I'm in working as an army.
No, that we
That we
understand. You were during appeal, you were on bail.
Yes, yes.
Whether that bail
In
is
trial, yes,
continuing,
yes, absolutely.
you are on previous bail.
Yes.
Shall remain on previous bail granted by the appellate court during the by the trial court
Trial
during the trial. Okay.
Good.
Dispose of that. Yes, yes, and somebody said very urgent. Who is yes, Mamu?
50.
He has taken a date
Who has taken?
on a.
After?
Yeah.
I think 50.
Yes, give it.
Here, my lord, the petitioner has been charged in NDPS case,
Then
showing him as absconder. Actually, he was never absconder, but he has been shown as absconder. In the same case, various persons have been granted bail by this Honorable High Court by 6 similar petitions we have annexed. Those petitions may be seen as 79 to 93. Bail has been granted, and asking the learned special judge to release them on bail of rupees 25,000. 6 order we have annexed. So that lordship may kindly see page 79 onward. So I also expect similar relief. I will appear.
no, these bails were granted prior to filing of charge sheet.
Prior to and after. No, after. After. Kindly see page 71.
PC Act. PC Act.
No, not PCA. NDPS. Similar orders, lordship may kindly see page.
Come to page 91. This is a similar order. Of
No,
what?
this is Supreme Court.
Page 90.
Yeah. Yeah.
Page 90.
Yes. 90.
It's a similar order.
It's similar order.
Now kindly come to the next page.
Yeah. Dibrugarh PS. It is Dibrugarh PS.
Can we grant bail under 482?
My lord,
Huh?
all these petitions are under.
No, may be granted. Are we having a power to grant bail under 482?
My lord, kindly see page 77. ma'am.
I have seen
No.
all the order.
Yes.
Tell me my power. Is it a binding precedent?
No, binding, not 482 is there, my lord.
For,
Uh,
there are specific bar.
Yes, specific.
Specific bar.
The summon has been issued in this case. So we want quashing of the summon and to release the other day. Summon have been issued in our name. We apprehend that if we appear, we can be maybe sent to jail.
So you want a quashing of someone.
Summon. Only summon.
Better take after vacation.
Maybe taken, but police,
Had it been a 438, we
I
could have
understand that.
considered.
There are so many orders, similar orders, so we did not.
Similar
I-
orders where law is laid down is binding upon us. When similar orders absolutely following the law laid down by the Supreme Court is not binding upon us, I can write it down in rejecting your order.
May I say one thing, one submission, my lord? In this regard, well, matter may be heard, but till then I may not be disturbed. That some limited. I understand that there are some bindings, there are some limitations, but
No, Mr. Mahmood, you are a seasoned counsel. You are a seasoned counsel. You file an 438 application. We may consider call for the scan copies. In the meantime, we may protect you. We'll look into it. We can grant you 430 even after filing of the search sheet.
Exactly.
But this is an application under 482, relying on some orders for granting bail under 482. I am not going to do it.
my lord, then my lord, I'll have to one there. I may be allowed to withdraw this petition. Tomorrow we will file.
File it.
Good.
Okay. Mr. Mahmood, learned counsel for the petitioner, prays that he may be allowed to withdraw the present application and to file an application under section 438. Prayer is allowed. The scan copies be retained along with this petition, petition. So that you make a mention, we'll call it tomorrow.
Yes, my. Hello.
There was some.
Yes, I understand. But it is filed by long back, not by me. I have been engaged to date.
It's not you or me, it's
Yes,
not
yes.
a question.
Law is,
Question is of
law
law.
is settled. Law is settled. Yes. Hello, oblige.
Yes, Mr. Chaudhary, is it not correct? Can we pass on 482 bail? No, the 438, even after search sheet we can.
I remember, my lord, if you will not to kindly permit, my lord, that is PN Choudhury. In one case, I filed a criminal petition in a case of Rajasthan. Criminal petition was there, but the Honorable Justice PN Choudhury, he not to know, he is very much well known judge. He granted me bail in the criminal division petition, asking me to appear, protecting me for 13 days.
But the law are changing.
Yes, yes.
These are not the days of my Lord Justice D.N. Choudhury.
Yes, changing. Almost every year, every past it is changing.
Yes. Naya, what is your case? Come. Item number?
Brief is on the way, my lord. It's a
Brief is on the way.
It's
Okay.
in the bench section, my lord.
Okay, then what remains is anything? Oh, hearing, forget about it. Keep it as per their contract.
For the hearing matter, your lordship, your lordship, in the last day, your lordship, on 8/9/23, your lordship, it was passed that they had not paid the compensation amount of 50%. Your order, your lordship passed the order on that day, your lordship. But till and 15 days was given to them to pay that compensation amount 50%. But till date, they have not paid that 50%, your lordship.
We'll take it after. They have wait for. There's shortage of time because you'll have to write at 3:15. We'll give a date as per your convenience. We'll take it up. You take 20 seconds. It's better for you.
May please your lordship. Lordship, I am appearing as respondent number 2 in a criminal revision petition. Otherwise, lordship, the matter is not very technical, but it is languishing since last 7 years on the ground of adjournments.
Which case?
Lordship, 53, item 53.
What is the issue?
Lordship, basically the revision was preferred against framing of charges.
Okay, we'll take immediately after.
Lordship.
Lordship, interim may be continued.
Deeply apply. Deeply apply.
Lordship, before learned counsel start.
Yes, Mr. Yes.
Only one judgment, your lordship.
But,
1997.
may I just pray for a leave? But I spoke to the secretary and I have received a copy of the order giving prosecution sanction on 13/10. Itu di.
13.
We have become wise after filing of this petition.
But at least it is my duty to bring it to your lordship's notice. My lord.
This is the problem.
But pursuant to your lordship's order dated 11/10, my lord, we have been given copy. Just telephonically, I contacted them and I got the copy.
Yes, Mr. Duff. You won't like to add anything?
After that, we now rules provide for a certain time frame for granting prosecution sanction. Within 7 working days after recommendation, that has to be accorded. Sanction has to be
Now,
accorded.
how you deal with the order of the learned court?
Well,
Is it a way to determine an application?
Yes, I understand. Earlier, my.
Is it a way?
Exactly.
Yes, we may dismiss his petition, but we want to send a message to the
My lord.
court. We'll see, we'll examine.
Therefore, my lord, may I-
Hard. Mr. Now, suppose we stay the proceeding. Now, what will happen? What benefit will you get?
Ultimately, your lordship will kindly see if your lordship the cognizance is taken without sanction. This is an illegality, your lordship. It goes to the root. Now, every stage of proceeding, your lordship will be, your lordship is a proceeding, it's a illegal proceeding going on.
That we understand, but what next?
Ultimately, your lordship will have to decide, your lordship, this issue, your lordship.
We'll decide it.
Lordship.
That will, so therefore we'll stay for a
Lord.
time being
That-
the
that's-
proceeding.
Your
Till the returnable date.
Lord,
And we'll examine it. This is an interesting issue.
Lord.
We'll issue, because in the meantime, what will be the implication
Of
of
the-
giving a sanction post cognizance?
Lord, that-
Cognizance will fall. Now, whether the this prosecution sanction can relate back, whether doctrine of relation back can be
will
made
be applicable
applicable
or
to an sanction order.
Lord.
These are
Lordship,
issues
this
to
is-
be
this is
determined.
the issue.
Hard, Mr. As Botapur, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor, appearing for the learned additional prosecutor, also heard senior government advocate, senior government advocate for the department of for the state of Assam in the Department of Home Affairs, Department of Home. Department of Home and Penco for appearing for Union of India, Ministry of Home Affairs. The present application is filed under section 482 of the Code of Criminal Procedure 1973 for passing of a proceeding being session case number 125/2023 in reference to Borpeta Police Station case number 175/2023 under section 120B/121/121-A of the IPC grade with section 10, 13 and 18 of UAP Act which is pending before the learned session judge Borpeta, inasmuch as an order dated
Lordship, this is order 13/9/2020.
13/9
2020,
where is the
page 89.
13/9/2023, whereby cognizance against the present accused along with some other under the aforesaid sections of law has been taken. The basic ground amongst other basic ground of challenge among other is that without there being any prosecution sanction as mandated under section 45 of the UAPA Act, the learned trial court has taken cognizance of the offences under part 2 of the UAPA Act, inasmuch as a specific plea was raised during the specific plea was raised by the accused person. However, the learned trial court has not dealt with the impugn order as well as proceeding. Admittedly, the prosecution sanction under section 45 of the UAPA Act was not there, and UAPA was not there, inasmuch as non-grant of sanction hits at the root of a case, more particularly by for the mandate of the section 45. This court is of the prima facie proof, inasmuch as this court is of the prima facie mandate of this case, inasmuch as it is well settled that when the provisions of provisions of law is stringent, the procedural part should be strictly adhered. Full stop. This matter needs further consideration. However, during the course of hearing, Mr. D. Nath, learned senior government advocate, has produced an order of sanction by the state government under section 45 (2) of the UAPA Act dated 13th of October 2023. That is, the sanction has been granted after the cognizance were taken. Full stop. Such fact also clarifies that on the date of taking cognizance, there was no sanction. Full stop. Be that as it may, this matter needs further consideration, and in the considered opinion of this court, the petitioner has been able to make out a prima facie case for further consideration. Inasmuch as admittedly on the date of cognizance there was no sanction under section 45 of the UAPA Act. Full stop. Considering the above, let a notice be issued returnable on after vacation at first, second, third week or third or fourth week.
Let me give it 24th.
24th of November 2023. In the meantime, the learned senior government advocate may bring on record by an affidavit the sanction granted, and the record for granting of such sanction kept ready not for the next date of hearing. Till such return of notice, further proceeding so far relating of so far relating to the present shall remain suspended.
Can it be on 28, Your Lord?
28.
Okay.
Have the record will see it.
No.
Yes. Next.
For the order I have given, that will be record.
Okay.
I have given a copy
Order
the
of
second.
sanction dated 13 10/20/23 produced by Mr. Nath is kept on record and marked as document. Yes. We are running fast.
Pilot.
Third, Mr. K.N. Chaudhary, Lanet Senior Counsel. Assisted by Sailva, President. And also heard, whom we have heard, Mr. Porua. R. Kaushik, Lanet Counsel for the petition. The present application is filed under section section 4 under section 439 of the criminal Code of Criminal Procedure 1973 for grant of bail to the petitioner who has been surseated in connection with Nazira Police Station case number 36/2023 registered under section 324/342/307/326/506 IPC. 506 IPC. Good stuff. 506 IPC. This code has called for the scanned copies of the proceeding as well as the case diary of the aforesaid case which has been received. In the FIR, it is alleged. Where is the FIR? In the FIR, it is alleged that it is alleged by the informant victim that while she was serving as a domestic help of the present petitioner, a police officer of Nazira subdivision in the district of Sibsagar, she was tortured by the informant and continued to physically assault her and tried to kill her by pouring hot water on her body and on several occasions compel her not to raise any objection by causing physical assault and by showing her high position as a high-rank police officer. It is further alleged that she was also confined in the bathroom and somehow she was able to escape from the quarters residence of the informant and could save her life. On the basis of the aforesaid FIR, the aforesaid Nazira Police Station case number 36/2023 was registered and investigation was initiated. After the completion of investigation, charge sheet was filed as discussed herein. The material so far collected, more particularly, the statement of the victim reveals that on the statement of the victim, it is alleged that on the fateful day, boiling hot water were poured upon the body of the victim and she was confined inside a bathroom. Full stop. The medical report also shows burn injury, fracture and bruise. And approximately 13% EPSA burn. Considering the material so far collected by the investigating authority, as well as the stage of the, this is not yet committed, stage of the trial. This court is of the view that the petitioner, at this stage, the petitioner is not entitled for grant of a bail under 439, more particularly considering the fact that she is a high-rank police officer and there is a scope for influencing and tampering with evidence, and such prayer can be considered only after examination of the victim, only after examination of the victim. Which therefore said that the present application for bail stands rejected.
Can be considered, otherwise it will be, my lord, that after that my yes.
No, can be considered.
On-
I have said can be considered. Let her first be examined. This is not a case for.
Okay, so inhuman.
What is your method? Give your paper.
Fine. It is on the way. My lord, much obliged. My lord, I was a circle officer in Len Revenue Circle, my lord, in 2008. During that, my lord, in that time, my lord, eviction operation was carried out in Singlijan Reserve Forest in the Assam-Arunachal border. My lord, that led to the registration of an FIR then, my lord. I did not know about it. My lord, now summons has come, my lord. A charge sheet was filed. If my lord peruses the charge sheet as well, my lord, there is no statement against me in the FIR itself, my lord. FIR.
But there are some cases I have dealt in Arunachal.
My lord. My lord, there is one of mine, my lord, where it has been quashed. In fact, the interim order I had annexed, my lord. The page, there is no prosecution sanction as well, my lord. This was of 2008, my lord, during that time.
No, regarding the same incident, this incident. Are you aware?
No, my lord. There are many FIRs in that, my lord. This one, the judgment, my lord, is of FIR number 17 of 2008. Same Balijan police station. It was
No. This was a criminal petition 10 of 2008.
My lord.
Regarding this border dispute, it happens. This
My lord.
forest officer goes there.
Yes, my lord.
There are some and
My
they counter.
My lord.
That we know.
My lord.
But so far, I remember on last occasion, 50 years back, when I was in station at Arunachal.
As Thakur was there and I was there, they pertain to my lord, Dibrugarh, Tinsukia district.
What happened?
FIR was lodged against my lord, this one ranger. And our grievance was that 197 sanction was not there.
I passed a stay order.
Stay was there.
Give it to him.
My lord, here also, my lord.
I gave him one citation.
Yes. My lord, in fact, my lord, an interim order, my lord, page 96, 97.
Where do I pass this order?
My lord, it's on the way, my lord. Criminal petition 1156 of 23, my lord. My lord, because the mention was made in court number 9, they had to again go to the registrar, my lord, for finalizing the list. There's no prosecution sanction, my lord. I have the letter from the government at page 95.
Do you remember the number of the case?
Yes, I can give. I recall the name, BP Dihingia. I have.
Have the copy?
My lord,
I'm just giving him.
Yes, Mr. Chaudhary.
Only my objection may be recorded.
Serious objection, not only objection. But where do we pass the order? So can you have the number?
My lord,
Then our job will be very
I'm just pending.
easier.
I'm just pending.
You were there. We passed the stay order.
my lord, in fact, this same stay order, my lord, is in page 96, 97.
Page 96.
96, 97.
Criminal petition 43 of 20.
43 of Arunachal, nahi yaar.
Incident of
Can we have this in our
I can mail him.
you have the order?
I can download and mail him.
Okay. Or you can give the Arunachal family.
If it's online, my lord, yes.
It's online.
My lord. Criminal petition 43.
Yes, my lord, I can mail him. Right. Mail quit.
See, Mr. Chaudhary, now the judges will have to give the judgment to the lawyer.
Yes.
এইটো আহিছে
এই আহিছে
সেইটো মেইলটো
Give a copy.
বেলেগ কেছেছ ফাইল কৰিছে কি আছে নাম্বাৰো হৈছে 1156
মেইল পাইছে পাইছে
There is holiday also.
yes my lord it's on vacation
vacation
okay and the appearance is tomorrow my lord
Gogo is with you, of course.
yes my lord
Gogo is with you.
petitioner and respondent are good together my lord I have seen
And in that case, he was a petitioner.
yes
my lord in this case my lord pro forma respondents 4 to 8 are the state my lord state of Assam my lord.
otherwise
They have support.
That's why you have made him a party.
My lord because of the lack of sanction
Here also search sheet number, tell us search sheet number.
yes my lord chart 9 of 2010 dated 3/11
9 of
2010
2010.
dated 3/11/2010
3/11/2010.
2010 and FIR my
In
lord
fact, in connection with
Balijan PS case number 10 of 2008
Balijan case number 10 of 2008. Corresponding to GR case number
GR case number 1 of 2008
under section.
under my lord charge sheet sections are different my lord charge sheet sections are 341 427 448 395 and 34
that will come my lord because this is the
but FIR my lord
And what is your
FIR.
designation?
my lord
You are a
my lord at that time circle officer my lord Helem revenue sir. At present joint secretary
Then what is your case?
my lord I
In
had
furtherance of your duty, your case was that in furtherance of his duty, when he tried to evict encroachers from the reserve forest belonging to state Assam, the alleged incident occurred and therefore the prosecution sanction was required to be taken before filing the
My-
charge.
my lord, I was a executive magistrate as circle officer I was discharging duty of executive magistrate in eviction in Singlijan Reserve Forest accompanied by Assam
From
Police and CRP.
Singrijan.
Singlijan SINGLIJAN under Helem Revenue and I was accompanied by Assam Police and CRP.
Now, this is your submission. Per contra, Mr. NNB Choudhury.
yes my lord
এটা আছে।
only thing is
The
that
Planet Additional State of Arunachal Pradesh submits that the area where petitioner has committed the offense falls within the territory of state of Arunachal Pradesh and
Yes, sir.
therefore when the accused has entered into Arunachal Pradesh for purpose eviction, he cannot get protection under section 197.
yes my lord
This argument we
that
have
is one
recorded.
dear my lord
This matter needs
yes,
further consideration.
Yes, sir.
Accordingly, is to notice returnable on
returnable after vacation my lord.
okay, give a date.
November.
November there more now after I 30 is oh
Would it be on first my
Hmm?
no, 1st of December.
নালাগে রে নভেম্বর
You give some short dates. We'll
Yes, sir.
extend the interim order. What is the problem?
22nd November.
NNB Choudhury, Lanet, additional application. Except notice on respondent number
আমি I am appearing for the restaurant number my lord.
1.
No one আরো আছে
No, Aruna.
As Mr. Gogoi accept notice on behalf of
5 and 8
5 and 8. No formal notice need be issued. However, extra copies. And so far relating to other, how
My
many?
lord, 6 is my lord, 4 is state of Assam.
প্রিন্সিপাল চিফ কনজারভেটর
Yes, state of forest.
this
But
can
6
be
is government of Assam.
Dipankernan's name can reflect because this Assam
D not for
My lord, 6, 4, 6 and 4, 6 and 7. my lord.
4, 6 and 7 D not. No formal notice need be. Till return of such notice, further proceeding of venture pending before
Judicial magistrate first class, UPR.
first class
Capital complex at UPR.
capital complex shall remain
Madam, 2 and 3 days, sir.
2 and 3.
Deeply obliged.
Look into
Deeply obliged. Extra obliged, my lord, for picking up without the brief, my lord. Deeply obliged.
yesterday we passed an order without the brief, then file came later. Now, of course, that was for correction of name. Yes, what is this? Rukia Khatun.
Yes.
Thousand 13. It is when
Yeah.
Huh?
Well,
How can police arrest her?
petition is not before.
Petitioner may not be before. See, oh no, sorry. He is having 2 daughters. Yeah. How many days she is inside?
And that is what I'm it records are not yet in a this what that is
26, 8, 9, 10. I think there was an attempt on her or something like that. What to do?
6 tomorrow. Then
non-APS. I can see the whole headache is on registry.
Lord.
I think he might be sitting in that court where this permission was granted. Permission granted in our court. Court number 9. Then why matter is stand here? Yes, Chaudhary, what to do? He is from 26-8. It seems that there was an attempt to be severed. 2 pieces. Then she is in jail from 2016. Almost
50 days.
Hmm?
50 days.
Huh?
Around
50 days.
50 days.
Not only she, other people were there. Were there now. I think you have portrayed
No.
or something like that. He's alive.
Let it be tomorrow, man. At least. Let it be tomorrow. Otherwise, the advocate may not know, my lord.
There is Venus. No.
Yes.
So the matter was listed by order on production. Non-APS certificate. This method. Yeah. Huh? Yeah.
Lord.
All over
Lord. Today I am totally my
today. Okay. We'll wait for them.